that top line. You see that top line there, 47976?
Yes.
And then there's 2 lines below that, 47978. You see those lines?
Yes.
Do you recognize those as being associated with the second location that you went to after the McDonald's, that CVS?
Yes.
To be accurate to say that you were still out of the home at 9:51 in the evening.
Yes.
Would it taken you, what, maybe like 5 to 10 minutes to drive back to the Temple address?
If that. Yes.
Okay. Probably about closer to 5 minutes.
Probably.
So then I'd like you to look at line 48008. You see that line?
48008.
Do you see it?
48008. Yes, I do.
That is the line from your timeline report that reflects when you dialed 911 and apparently hit send.
Mm-hmm.
You see that?
Yes.
And you see the time, 10:52?
Yes.
So you'd agree with me that the entire sequence of events that you describe having occurred upon your arrival had to have happened in less than an hour.
Yes.
Ms. Redlick, I'm now showing you photographs from the CSI photo exhibit, specifically photograph 3031. Do you recognize that as your vehicle?
Yes.
You recognize that as the vehicle that you were in the drive-thru in?
Yes.
Showing you photograph 3034. You recognize that as Michael's vehicle.
Yes.
Showing you photograph 3574. You recognize the interior of Michael's vehicle.
Yes.
And specifically, you recognize that there are eggshells on the seat right here in the driver's seat.
Yes.
You see that?
I do.
You see the eggshells, you'd agree, here in the sort of door sill as well, correct?
I do.
As well as the egg yolk that's up here near the steering wheel.
Yes.
Michael didn't egg his own vehicle.
No.
You did.
Yes.
You heard the testimony of Detective Ware that she saw a yolky substance actually on his pants. You heard that testimony?
Yes.
In addition to egging Michael's vehicle, you also threw eggs on Michael's person.
No.
So you don't know how that egg residue got on his pants?
Probably from the car. When he got out, the door was closed when I threw the eggs at the car.
The door was closed when you threw the eggs?
I believe so, yes. I'm assuming when he opened the door, the eggs dropped down and fell into his car.
Okay. And your testimony before this jury is that that incident occurred before Sawyer's football game.
Yes.
So like in the 7 o'clock range.
Yep.
And your testimony before this jury is that you did that. You got eggs, these eggs, I assume,
Yes.
because Michael had taken your cell phone.
Correct.
So your response to Michael taking your cell phone is to go in the home, go in the refrigerator, and get a pack of eggs, correct?
Yes.
Michael is out, he's in his car, and to get your cell phone back, you start pelting his car with eggs.
I threw some eggs at his car, yes.
You did that before Michael left.
Yes.
So if Michael got eggs in his car, on his person, he, of course, didn't take apparently any efforts to clean himself off or clean any of the eggs out before he drove off to the football game, clearly.
Objection, speculation.
Hold on. Overruled. You can answer the question. No, he got in his car and left. I don't think it was that much on his pants either. So
got in his car, sat on the eggs, left the eggs in his door sill, just did nothing about all the eggs and egg yolk that you had just covered him with before he went to this football game.
apparently not.
Was Jaden home during this egg throwing incident?
No, Jaden left. Jaden was gone.
Jaden was home during the incident where you claim that Mr. Redlick broke the door to the primary bathroom.
Both children were home, yes.
Yes?
It's been a while, yes.
You want to look at it?
It's okay. No,
You doubt it's your phone?
no, I trust you.
Your phone was in working order the evening of January 11th into the 12th, correct?
Yes.
Nothing broken about it.
No, I don't think so.
You don't think so?
I don't recall. I don't believe my phone was broken. No, I don't remember that.
Are you saying it's possible it was broken?
Possible because I don't remember, but
Your phone number was 901-355-4234, correct?
yes,
And Michael's phone number was 408-829-1960, correct?
yes,
And you used that cell phone to exchange text messages with Michael frequently.
yes,
Specifically, on the date of the 11th, you exchanged messages.
yes,
You used this phone to sign up for the Meet Mindful account, correct?
I don't know. There was a couple of phones in evidence, so I'm not really sure, but I think I used my email to sign up for Meet Mindful.
Well, you logged, but you browsed to Meet Mindful here on this phone, did
Whatever
you
phone
not?
I was using, yes.
I'm going to show you what's in evidence of states 44. These are the Meet Mindful records, Ms. Redlick. Look at page 5. And the line became active, 12/5/18. Is that consistent with your recollection whenever you created your account on meetmindful.com?
Sounds about right.
And with creating your account on meetmindful.com, you listed your dating status as separated, did you not?
Okay, yes.
That was a lie.
At that point, I suppose, yes.
Ms. Redlick, a little more than a week later, showing you what's in evidence as states 58, the email drafted on 12/14/2018, or sent rather on 12/14/2018, you sent this email. Read the email to the jury, please, Ms. Redlick.
You are a lying, rotten son of a bitch. Nice way to talk about your daughter, too. I'm done with you, Mike. We should talk about ending this. I'm ready. You are the most untrustworthy person I've ever known. And I have every right to choose not to be with that kind of person. You had every opportunity to tell me about this the other night. 2012, really.
Ms. Redlick, my understanding from your direct testimony was that you had access to Mr. Redlick's email account, correct?
Yes,
On December 14th, 2018, you went into Mr. Redlick's email account, yes?
I think so, yes.
You were browsing Mr. Redlick's email account back to messages that were sent and received on 2012, correct?
Yeah, I think I was looking through his LinkedIn.
You were looking through his email, not his LinkedIn.
Okay.
right?
Yes.
And the messages that you were sort of scrolling through, were all the way back in 2012, correct?
I suppose.
While digging back through time, you come across this particular email. An email between Michael Redlick and someone named E. Corrigan at brooks.edu, correct?
Yes.
Ms. Redlick, you explained on direct that Michael was previously married to a woman named Kim Corrigan. Did you not?
Yes. Or Corrigan. Yes. I'm not sure the first name.
Well, you said Kim Corrigan in your direct.
I said that name rang a bell. I know he was married to a Corrigan.
Okay. You don't know if this is the same Corrigan.
I think I was tipped off on the LinkedIn first, and I suspected that that was the Corrigan.
But you're not sure.
No.
So not being sure of who this actually was, you sent this email in anger at Mike.
Yes.
You acknowledge that this email is hypocritical, do you not?
I do.
Because at the same time that you are sending this email, you are a couple of, few days past a week into being on Meet Mindful, yes?
Yes.
Matching with people on Meet Mindful, yes?
Yes.
And exchanging messages with men on Meet Mindful.
Yes.
Michael doesn't know that on December 14th, 2018, does he not?
He does not.
In fact, in December, around this time period, Michael is wanting to make this marriage work.
I was under that impression for the most part.
So yes, he was.
Yes.
On the other hand, Ms. Redlick had not wanted to be married to Michael for years.
No, I wouldn't say that's true.
You wouldn't say that's true.
No, that I didn't want to be married to him for years. Sorry, can you repeat the question?
Yeah, you had not wanted to be married to Michael for years.
No, I wouldn't say that's true.
You filed for divorce in March of 2019, correct?
Yes.
And you told this jury that after you filed for divorce, Michael started weaponizing the divorce, did he not?
Yes.
He would threaten you with the prospect of basically leaving you destitute,
Yes.
out on the street,
Yes.
with no money
Yes.
and no Winter Park home.
Right.
A couple of months before the actual divorce, he had moved out of about a month after you filed for divorce, he moved out of the house, about April, if I recall correctly.
Yeah, and it wasn't even quite a month. It was a couple weeks.
You were happier when Michael wasn't living in that home, were you not?
No, because he was there all the time. And essentially, it was like he was still living there. We just weren't.
When Michael wasn't at the house, you were happier.
Not necessarily, no.
So you're not saying that Michael's presence made you unhappy?
Our fighting, and yes, his presence when we're fighting, yes. And
So when you were at the house and Michael wasn't there, that was a better environment for you.
for the kids, yes. And yes,
And you.
yes.
You never wanted Michael to move back into that home.
I wanted my marriage to work deep down.
You never wanted Michael to move back into that home. You testified to that on direct, that you did not want him to return.
No, I didn't, yes.
A life without Michael Redlick was a life that you were looking forward to living.
Well, life at peace with Michael Redlick.
Without him in your life as your husband.
If it was not going to be at peace, then no. But not with no. He's the father of my children. He's not going to be out of my life.
Oh, not entirely, but you wanted a life beyond Michael, correct?
Yes, at that point, yes.
You recognize the name Eric Barker, do you not?
I do.
Eric Barker is a criminal defense attorney, correct?
Objection, Your Honor. Can we approach?
Barker is a criminal defense attorney, correct?
Yes.
And at one point in time, you were considering hiring Mr. Barker as a criminal defense attorney, correct?
Objection, relevance.
Not necessarily.
Just waiting to come back. Mr. Parnell, come up. Ask
There-
the question again, Mr. Wiggins.
There was a moment in time that you were considering hiring Mr. Barker as your defense attorney, correct?
I don't know that I was considering that. I was listening to him.
Well, you met with him, correct?
Yes.
And you consulted with him about the facts of your case.
Yes.
Ms. Redlick. During the course of this incident, you armed yourself with a knife, did you not?
Yes.
And in your direct testimony, you said that you used a, quote, long knife to kill your husband, correct?
Yes.
Which knife did you use to kill your husband?
A long knife with a brown handle.
The one on the floor?
Yes.
You cleaned that knife afterwards, correct?
No.
So that it never made it into the sink.
No.
You said that you used a sharper knife to slit your own wrist, correct?
Yes.
Which knife did you use to slit your wrists?
It was a silver one.
That was in the sink.
I think it was.
So that knife made it into the sink.
So,
Did you clean that knife after you slit your wrists?
I don't recall cleaning it. No.
So the knife that you selected to stab your husband was a bit duller, correct?
I suppose.
Let's talk about the actual or your story regarding the death of your husband. You have told this jury that he has taken a bite of your hamburger, correct?
Yes.
And then he spits it at you,
Yes.
right? It's at this point that you stand up
Yes.
and you grab that McDonald's bag and such, and you begin to throw it on the counter or the island, right?
Right.
Mr. Redlick is behind you,
Yes.
and you feel yourself get hit in the head.
He grabs me and I fall. Then I get hit in the head.
I thought you stumbled.
Yeah. Well, he grabbed me first, which I tried to turn, and then I tripped up on my feet and fell.
So you fall, and then it's while you are still on the ground that you feel something hit your head.
Yes.
Could you tell if it was an object or a fist or something else?
Elbow, fist. I don't know what it was.
But not like a blunt object like a bat or a mallet.
I didn't think it was an object. No.
It's at that point that you are pulled back up by your hair. Is that what happens next?
Well, I attempted to get up on my own, and he was too far on top of me. So
Where are you at when he's now too far on top of you?
coming up, trying to get up off the ground.
Where specifically? Where specifically, or is he too far on top of you to get on top of you?
So am I using this?
Permission to allow the witness to use the laser pointer, Your Honor?
Yes, that's fine.
I do this.
I might need to turn it on for you. So, put the laser pointer to where you were whenever he was too far on top of you for you to get up, please.
I'm in this corridor between here and here,
Okay. So,
facing that way, on my knees.
on your knees, facing towards the cabinets on the far wall where the scale is at. Yes? And when you say he's too on top of you to get up, is he actually standing? He's standing over you at this point?
Yes.
And is it this point that he picks you up and by the hair?
No, I'm going to get up like this, and I don't know where exactly he's at, but I know his head slammed into my head.
So as you're getting up, you feel your head on his head.
I feel the back of my head on his head.
Then it's at that point that he takes your head and he slams it onto the stovetop area. Yes?
No, I wouldn't say right at that point. No. I reached up and with my right hand to pull myself up. And as I'm pulling myself up and trying to turn around to face him, that's when he grabbed my hair and slammed my head onto the.
Slams your head into the stovetop. Yes?
Yes.
And at this point, you have a 6'1", 240-pound man pressed against your body. Yes?
Yes.
Pressing you against that island.
Yes.
The next thing that you say happens is that he begins to take his fist and he's rubbing it in your face. That was your story, right?
Took my head and he held it down. It was a very awkward position. I couldn't move because it was hurting. And yes, he had me pinned. So he held my head down first.
So your neck is sort of like cricked against the corner of that island at that point.
Yes.
Now he's using this force to keep your head down.
Mm-hmm. Yes.
And he is still on top of you. His 240-pound body is still pressing you into that island.
Yes.
You can feel the island on your body.
Yes.
This is when the rubbing happens?
Yes.
'Cause he doesn't hit you.
Doesn't punch me, no. Well, he hit me in the back of the head, but
In the back, where your hair covers, correct?
yes.
On the skin that's exposed, he doesn't strike. And then is it at this moment that he decides that he's going to put his hands over your nose and mouth?
Yes.
As I understood it, you are at this point sort of turned sort of a little bit over, correct?
Right.
So your side and your arms are sort of being pressed into the island.
Yes.
At this moment, this 240-pound man is putting all of his weight and effort and rage into your body,
Yes.
and you can feel it in your ribs.
No, I can feel it on my face and my head.
You don't remember feeling anything in your ribs as he's crushing you into that island?
I mean, yes, the whole left side of my body was hurting.
So he's on top of you, pressing you with all that rage and all that might. And you are, as I understand it, able to, with him on top, reach over with your left hand or right hand to locate the knife.
My right hand, that was the only free hand I had.
Is his chest on you?
Um,
His chest is sort of pressing into you?
no.
More his stomach and his arms?
More his legs and his arms, yes.
Okay, so with the free hand, you are able to grab the knife from that far drawer at the end.
Yes.
Your testimony is that he doesn't immediately react to you getting the knife, correct?
He reacts, he lets my head go.
A little bit.
Yes.
And when he lets your head go, you're able to go from sort of this position to more like this position.
Able to break my arm free. Yeah, the left arm.
And now you're kind of squared up with Mr. Redlick.
I wouldn't say squared up. I don't know. It was kind of an awkward feeling, so.
More squared than you were. You're not sort of twisted like you were before.
Right.
You're sort of more
My legs are still kind of twisted, but
legs are twisted, but now your back is kind of more square than it was before.
yes, I'd say that.
And Mr. Redlick is still right there pressed up against you.
Yes.
And his reaction to, because he doesn't have his hands on your mouth anymore, right?
Right.
His reaction, and he's still full of this rage, correct?
Yes.
You see it in his eyes.
Yes.
He's angry.
Yes.
And you think that he's going to maybe kill you in this moment.
Yes.
And he sees you with the knife. And his reaction, you say, is he takes his hand and he shoves with all of his might. Correct?
Yes.
And so now you feel that the edge of that marble pressed into you.
Somewhat. Yes.
So he wasn't pushing that hard?
Yes. I mean, I felt it. Yes.
Because he's pushing hard.
He shoved me. Yes. He shoved my face back. Yes.
Well, if it wasn't that hard, you should tell the jury if it wasn't that hard.
Just that my lower body was kind of twisted. So, and I know what I felt, but I don't know how it looked.
But you're not saying he didn't use an extraordinary amount of force to sort of push you back against that island, correct?
He absolutely used force to push my head back. Yes.
And it's in that moment that you take the knife and you jab it into his shoulder.
Right.
But that doesn't stop him. That doesn't dissuade him, correct?
After he stabbed. Yes. After he was stabbed.
Well, yesterday you said that he still kind of kept coming after he was stabbed.
I don't know that I said that.
You said there wasn't an immediate reaction to him being stabbed and that he sort of continued to force himself on you for.
When I grabbed the knife and I held it again toward him, he did not stop.
So he stops when he gets stabbed. That's your testimony today.
Yes. I mean, yes.
So you're able to go from sort of this position now more upright.
Yes.
You sort of feel the release of pressure off your back. Yes?
I feel the release and pressure of him off of me.
You feel his hand, which had been forcing pushed on your face come off, correct?
Yes.
And he is standing there and he begins to bleed. Yes?
I don't know. I ran.
You ran. So let's talk about that. You told the 911 operator the altercation started at 10:30, correct?
Yes, I think.
You also told the 911 operator that you heard moaning from the bathroom, correct?
I think I did say moaning at one point.
So when you're in the bathroom and you're hearing moaning, Michael's alive.
Yes.
Do you recall telling the 911 operator that after you emerged from the bathroom, you found Michael on the floor and you tried to give him mouth to mouth? You remember saying that, yes?
That I did what now? I'm sorry.
That you gave him mouth to mouth after you emerged.
Yes.
And you testified to that yesterday.
Yes.
You also talked to Terrell Tucker about that, didn't you?
Yes.
And in fact, you told Terrell Tucker that you gave him mouth to mouth until you vomited on him, correct?
No, I did not say that. She's totally wrong about that.
She's wrong about that.
Yes.
When you were sitting with Terrell Tucker, you saw her writing notes when you were talking, right?
I saw her handwriting notes,
Okay.
and I said I smelled something like vomit from coming, but there was no vomit. I said it smelled like vomit. So she got that wrong.
I want some clarity. So you come out, you say it's about 15 minutes, you think you're in, correct?
I don't really know how long. It was a while. It wasn't quick,
Had to be less than an hour, though, we know.
right?
So when you come out and you see him, you think he might be being dramatic at first, correct?
That was just an initial thought. Yes, I was shocked.
And then there's blood everywhere.
It's quite a bit of blood.
And you're looking at your husband who's on the floor, not responding, yes?
Yes.
And the first thing that you did was you lift his shirt up to look at the wound, correct? Well, let me phrase it like this. You eventually say you do mouth to mouth on him, right?
Yes.
But before you do mouth to mouth, you lift up his shirt and you look at the wound.
Yes.
And you actually press your hand on that wound and watch the blood flow under your fingers.
I don't know that I got on my fingers, but yes, I saw it.
Well, you touched a wound and blood didn't get on you?
I saw blood come out. That's all I recall.
When you pressed on the wound.
Yes.
Then you do the CPR.
Yes.
But before you do the CPR, you are engaged in this effort to find your phone. Can't find your phone, right?
Right.
And you're looking and this phone, you said, you see it. It was camouflage. It was camouflage on a black jacket.
Yes.
This phone, right? So it's camouflage on the black jacket. You see it, and you get it, right?
Yes.
And you are standing in the immediate proximity of your husband,
Yes.
looking down on him, unresponsive,
Yes.
having seen that wound and pressed on that wound and seen the blood flow, yes?
Yes.
And you realize this is serious.
Yes.
And you think to yourself, I should call 911 because he needs help, correct?
Yes.
He needs professionals to come in and try to save his life.
I don't believe that he was dead at that point.
You didn't believe he was dead.
I said I believe he was dead. Yes.
So you did CPR on a dead man?
At that moment, I was hoping that he wasn't.
Okay, so you thought there was a chance that this man could still be saved. Because otherwise you wouldn't have done CPR,
I
right?
suppose, yes.
So you're standing there, you have your phone in your hand, you know, I think this man could be saved. And the best way of saving him is to dial 911, correct, Ms. Redlick?
Yes.
You mentioned on direct that you had no business doing CPR, did you not?
Yes, I'm not trained.
You're not trained. You have no idea how to do CPR.
No.
You've never given mouth to mouth on a person or a dummy or anyone.
No.
So standing there over your husband in this moment where you think he can be saved, knowing that 911 is the route to that possibility.
Yes.
You set your phone down.
Objection, misstating her testimony.
Well, just keep your phone in your hand.
I'll sustain that.
I don't remember. I just remember looking at his face and I was freaking out and I'm like, well, and I guess my thought was,
Well, no. I'm not asking what your thought was. I don't care where your phone was at. What I do care about is you're standing over him. You thought I can call 911 right now. And instead of doing that, Ms. Redlick,
Objection, again, misstating her testimony.
Overruled.
instead of taking your finger and doing three little moves, 911, you begin to perform amateur CPR on him, correct?
yes,
So you stood in that home with the power to call for help, and you let your husband bleed to death on that floor.
he had already bled to death. When I was doing the blowing into his mouth, I was wondering if I could recover him or something. I didn't,
So which is it?
and I thought there.
Objection.
that
Can
needed to
she
be done
answer the question?
immediately. So
Hold on, stop. Let her finish the question. You said, Ms. Redlick, I was wondering if I could recover him or something. I didn't. And Mr. Wiggins, your question was, so which one is it? That's the last question.
Which one is it? Is he dead, or you think it's possible to save
well,
him?
if he could be recovered, something would have to be done immediately. And so, yes, I thought perhaps I should do that.
So are you telling this jury that you thought it was impossible to both dial 911 and do CPR? You thought
No,
it was
it's not
either or?
impossible. No.
So you could have done it,
Yes,
and you chose not to.
I dialed 911 right after that.
No. You in that moment you chose not to.
Right.
So in these fleeting moments, you think Mr. Redlick can be saved. You choose not to save him.
I wouldn't put it that way. No.
It is at 10:52 that you make this one and only sort of attempt at a 911 call. You hit 911, correct?
Yes.
And you know that it doesn't connect.
Yes.
No one's on the other end of that attempt.
No.
We're now heading towards 11 o'clock, correct?
Yes.
At 11 o'clock on January 11th, 2019, you knew Mr. Redlick was dead.
Yes.
No doubt.
No doubt.
You were awake.
Yes.
And it's at this point you begin to clean up the scene.
Yes, somewhat.
So the cleaning effort starts very shortly after you realize Mr. Redlick is dead.
Yes.
You had your phone in the 11 o'clock hour, correct?
Yes.
You're using your phone in the 11 o'clock hour.
I think I had my phone. Yes.
Well, you were using your phone in the 11 o'clock hour.
I don't know that I was using it.
Well, what hour do you think you started deleting text messages?
I guess it was between 11 and 12 or something like that.
So 11 o'clock hour, you're beginning to delete stuff from your phone, correct?
Or midnight hour. I'm not sure.
Did not call 911 in the 11 o'clock hour.
No.
All right. So now it's midnight. You're still awake
Yes.
and you're still cleaning the house.
No.
So you think your entire cleanup effort was from 11 to midnight?
There was some in the morning too. I don't know. There was an entire hour of cleaning. No.
Was it sort of sporadic through the time that you were awake?
I think it was pretty concentrated in that initial attempt.
And the concentration actually is, you start in the kitchen, do you not, Miss Redlick?
I don't remember where I started. There were towels everywhere. I was slipping in blood. I was just wiping up blood. And
Mops?
the mop I think I used in the kitchen area, but that was it.
You got some cleaner out?
No, I don't remember getting cleaner out.
This is some of the towels and the mop and the bucket that you used when you began to clean the scene, correct?
Yes.
And amongst those towels is a t-shirt, correct?
I guess, yes.
Well, you put it there, right?
I don't remember. I mean, you're telling me it's there, then it's there.
You doubt that it's there?
No.
You've been sitting through this trial, correct?
Yes.
This is Michael's shirt, correct?
Yes.
You took that shirt off his body, correct?
Yes.
What hour did you decide to start taking his clothes off?
That was when I was assessing the situation,
Well,
when I found him.
yesterday you said you just kind of lifted his shirt up a little bit. You didn't say anything about taking his shirt off yesterday.
Initially, I just lifted the shirt.
So when does the shirt come off?
I don't know, shortly after that.
That had to take a lot of effort, right?
I don't remember.
He's a large man.
Yes.
He's dead weight,
Yes.
literally. And you have to kind of move him up and wiggle his shirt off, correct?
Yes.
And everything that you have wrought upon him is laid bare to you at this point, correct?
Yes.
And while you're cleaning, you take that shirt and you throw it amongst the towels that you've been using to alter the scene, correct?
No, I think in the morning I was gathering up more of the towels and putting them in a pile.
So this was part of the morning cleanup.
I believe so. Yes.
Ms. Redlick, I'm showing you photograph 3438. This is the kitchen area, correct?
Yes.
This is right next to the knife you said you used to kill your husband, correct?
Yes.
This would have been one of the areas that you got the mop out for, right?
Yes.
There's a lot of blood in this area.
Yes.
And would this have been part of the nighttime cleaning or the morning cleaning?
The mopping?
Yes.
I want to say it was at night.
Think you used the mop both at night and in the morning?
No, I don't think so.
So mop at night, mop and towels at night, but just towels in the morning?
I was just picking up the towels in the morning.
Okay, so it is now 1 o'clock in the morning. You're awake.
You might be still awake. Yes.
You were awake, correct? Are you still cleaning at 1 o'clock in the morning?
No.
You were cleaning after midnight, yes?
Times are, I'm not real positive, but
You have your phone, yes?
yes.
You know Mr. Redlick is dead on the floor, yes?
Yes.
And you do not call 911.
No.
You would have this jury believe that you fell asleep next to your dead husband, correct?
Proper question, objection and proper questioning.
What's the question?
You would have this jury believe that you fell asleep next to your dead husband.
Yes, eventually.
And that would have been in the 1 o'clock hour, correct?
Don't know exactly when I fell asleep.
Could have been later than 1 o'clock.
I don't know.
You believe you woke up at 7 o'clock, correct?
Yes.
And you wake up at 7, you still have your phone.
Yes.
It's still working.
Yes.
And you begin sort of, at this point now, we know, picking up towels and sort of tidying things up some more.
I don't know if I did it right at that moment.
Okay. Could have been a little later.
Yeah.
At some point, Ms. Redlick, you turned the focus from cleaning the house to cleaning yourself, correct?
I think I rinsed my hands a couple times, yes.
So you went in the shower and you were cleaning blood off yourself.
No, I was near the linen closet at that point. I do remember touching that handle. I think I attempted to, I don't know if I actually turned it on or not, but I was thinking about washing my hand under the shower head at that point as I was,
Went over to the sink and tried to wash yourself up.
I might have washed my hands there,
Was
yes.
this in the morning or in the evening?
I don't remember.
Clean yourself more than once?
I don't remember. I didn't clean myself up very much at all. I changed my pants in the morning.
As part of your cleaning effort, you started throwing things away. Yes?
Yeah, I believe that was in the morning.
This is part of the morning cleanup.
I believe so, yes.
And it appears at some point during this cleanup, Ms. Redlick, that you get thirsty, right?
No,
Well, you handle that jug of milk with blood on it, with blood on your hands, correct?
yes, I did.
So were you modifying the scene or were you getting a glass of milk?
The milk was out on the counter because I gave Sawyer a glass of milk the night before.
So this was part of changing the scene, modifying the scene.
I walked
Objection,
to the
argument.
kitchen
Hold on.
And I threw away,
Ms. Redlick,
I'm
hold
sorry,
on.
I'm sorry.
You say it's argumentative?
Yes.
No. Overruled. You can answer that.
Okay, and the question is again, I'm sorry.
Where was it, Ms. Redlick?
On the counter?
Where on the counter?
I don't know. I don't remember.
But we're talking about in the kitchen area.
Yes,
Hadn't been knocked over in this whole attack, correct?
it's a big kitchen area. There's a lot of counter. No, I don't believe it was knocked over.
But you can't remember.
No.
But it's out in the area where you say this attack occurred, and you're picking it up and you're putting it away.
I don't know that it was in the exact spot of the attack because that's the stovetop, so it was in a different area.
You mentioned the stovetop. Is that as the stovetop, Ms. Redlick?
I do.
What's that just placed there on the stovetop?
It's a lemon.
As part of your cleanup effort, that in the area that you say this attack occurred, there was blood from Michael, correct?
Not in that direct area the stovetop, in front of the stovetop, no.
So he didn't bleed much in front of the stovetop.
I didn't notice any blood there, no.
Not much cleaning to do in the area of the attack.
No.
Okay, so 7 o'clock, you begin to search how to slit your wrists, correct?
Yes,
And your explanation for why you began to do this is you began to think about your kids, correct?
yes,
And so while you think about your kids and you think about beginning to take your own life.
very irrational, yes.
We move to the 8 o'clock hour. Miss Redlick, you still have your phone. You do not call 911.
No.
You are continuing to tidy up the house, correct?
I don't know what I was doing at that point.
Possible that you were still engaging in moving things around and picking things up, yes?
Possible.
And in the 8 o'clock hour, you are continuing to search on how to slit your own wrists, right?
I don't remember. If it's on there, then yes.
Looking at the timeline report help refresh your recollection?
No, I believe you. It's fine.
Well, I don't want you to believe me. It's what I say doesn't matter. It's what you say. Do you remember looking up how to slit
I'd
your
have to
wrist?
see it then.
Okay, let's see it. I'm at 38 seconds. How long to die before you slit your wrists?
Okay, yes.
So 8 o'clock hour on your phone, using your phone to Google how to slit your wrist, correct?
Yes.
It would be accurate to say that if you're still Googling how to slit your wrist, you haven't slit your wrist yet. You to do Google searches on how to slit your wrist in that 821 range, correct?
Yes.
You do not flip over to the phone app and dial 911 at this point, correct?
Correct.
Now we move to the 9 o'clock hour. Have you slit your wrist yet?
I don't know.
How soon before you call 911 did you slit your wrists?
I don't remember. I don't know.
Well, how long did you let yourself bleed, Miss Redlick, before you dialed 911?
I don't remember how long I bled. I just don't remember. I don't know.
Was it an hour? You let yourself bleed for an hour?
Let myself bleed. I don't know that you can stop yourself from bleeding.
You're right. That's a bad question. Did you let yourself bleed without calling 911 for an hour?
I don't know. I don't. Yes, if at that point I slit my wrist, then yes.
Well, at what point did you slit your wrist? You haven't said.
I don't remember. I don't.
So let's look at the knives, Miss Redlick. This is the knife you killed Michael Redlick with.
It's the knife I stabbed him with. Yes.
It's the knife that caused him to die.
Yes.
Is that where you dropped it and left it after you stabbed him?
No, I didn't drop it. I left it with him.
You left it with him?
I didn't drop the knife onto the ground.
Yesterday, in your direct examination, you said that the knife just kind of dropped
I let go of the knife.
and gravity acted upon it.
I guess it dropped. I don't know. I didn't see it. I ran the opposite direction.
And actually, yesterday, you said that you felt like the attack was still ongoing, right? It had not ceased.
Yes.
And while the attack is still ongoing, you let go of this deadly instrument, correct?
When the attack was still ongoing was after I let go, meaning
Yes, you felt the attack was still ongoing after you stabbed him.
yes.
And in that
Could've
moment
been.
where you say the attack was still ongoing, you let go of the weapon and it drops, or not. I don't know what your testimony is today, correct?
He let go of me and then I let go.
But you thought the threat was still there
Yes.
and you let go of the weapon
Yes.
in the immediate proximity of your attacker, correct?
Yes.
And turned your back on him.
Because he let me go.
But you thought the attack was still coming.
I thought perhaps it could. So
That
how
is
would I
not the
get
final
away?
resting place of the knife, is it, Miss Redlick?
I don't. It very well could not be. I don't.
Because you're mopping in that area.
Right.
So you would have picked the knife up that you used to kill Mr. Redlick at some point. Yes?
I could have touched the knife. Yes.
Well, it's not a could have, Miss Redlick. You know what you did. What did you do?
Objection, argumentative.
Same.
Tell this jury what you did with the knife after you emerged and Mr. Redlick is dead on the floor.
Objection. Can counsel ask questions?
I don't understand. What's the question again?
Repeat your question, Mr.
Miss Redlick,
Yeah.
tell this jury what you did with the knife after you emerged and found Mr. Redlick dead on the floor.
I didn't do anything with the knife. I don't. At some point, it might have gotten moved when I was moving things, the towels and stuff.
Was there someone else in the house?
No,
So when you say it might have gotten moved, who moved it?
he or I.
So you're saying Mr. Redlick moved the knife?
I don't know what happened. I don't know what. I don't know. I understand the question.
The question is, I want to know what you did with the murder weapon after you murdered Mr.
Objection.
Redlick.
Argumentative.
Overruled.
I stabbed him and I ran to the bathroom. So I don't know what happened to the knife at that point.
Okay.
However, it could have possibly been on the floor there, and I never picked it up to clean it or do any of that. So
So is that your testimony? Your testimony is that you clean up the McDonald's and you move the milk and you get the mop out, but the murder weapon you leave right where you found it. Is that your testimony to this jury?
I don't know that I found it per se there. It could have been moved. However, I was not intending to touch that. Yes.
It is still not clear to me whether you touched it or not. Did you touch the knife?
I might have, yes.
You remember
But I also knew it was what I used to stab him. So, you know,
Okay. So you might have. So we'll leave it at that, Miss Redlick. The knife that you used to slit your own wrists,
yes,
is it that silver knife right here?
that's it. Yes,
That's the sharp knife that you used to slit your own wrists.
yes.
And after you slit your wrist, you put it in the safe.
Well, that was after I slit my wrist. I think this was all before 911.
Well, where'd you slit your wrist at?
Um,
In the home.
I don't even remember that.
Miss Redlick, you did not slit your wrist because you wanted to be with Michael in the afterlife, did you?
I don't know if I was thinking rationally about anything at that point.
Miss Redlick, you slit your wrist because you didn't want to be in that chair answering for what you're having to answer for today. Isn't that true?
There were a lot of things going through my mind.
And that was one of them. You didn't want to have to answer for what you did. And so that's why you slit your wrists.
I was concerned. I was afraid.
One of the reasons why you slit your wrists is because you didn't want to have to answer for
Objection.
what you
Asked
did.
and answered.
Didn't answer my question.
Did not. Objection is overruled. Repeat your question, Mr. Wiggins.
One of the reasons why you slit your wrists is because you didn't want to have to answer for what you did.
I suppose that could be one.
Okay. Miss Redlick, it is only when you are bleeding that you dial 911, correct?
After I was bleeding, yes.
So after you bleed is when you use your finger to make those 3 motions.
Yes.
All right, Miss Redlick, let's talk about a few other things. I'd like to discuss some of the statements that you've made through the course of this case. You admit now in trial that you killed your husband, correct?
Yes.
On January 18th, 2019, law enforcement showed up at your house.
Yes.
They showed up to execute a search warrant.
Yes.
Execute a search warrant on your person to get a DNA standard from you, correct?
Yes.
And to search your home, correct?
Yes.
You were at your home when the police arrived,
Yes.
and you were placed into a vehicle by Detective Ware.
Yes.
And you recall her reading a search warrant to you.
Yes.
Let's play that portion, Miss Redlick. Okay, we're going to publish what's in evidence as States 41. And we're going to start from the 5-minute and 20-second mark, Ms. Redlick.
Needed without coming back before the court. A proper inventory and receipt shall be given for any evidence seized, and a completed duplicate copy of the search warrant shall be delivered to Danielle Redlick or left with his or her property. An original of the search warrant and return reporting the execution of the warrant, and an inventory of any evidence or property seized under the search warrant shall be filed with the court within 10 days of the date of issuance. It is further directed that any evidence or property seized under this warrant shall be brought before a court having proper jurisdiction to be disposed of. I did not murder my husband. Please, I don't understand the jargon. To law upon request, ordered and sealed this 16th day of January 2019, signed by Judge Gail A. Adams. Okay. That I don't understand. You're saying the saliva, when there was resuscitation done, that's second degree murder? No, I'm collecting saliva samples from you, as is in this warrant, to be tested. Because of the resuscitation? Because of.
Ms. Redlick, you just heard yourself tell Detective Ware that you did not murder your husband. You heard that?
Yes.
You were lying to her when you told her that, correct?
I stabbed my husband. I don't consider it. Wasn't considering that murder.
Oh, so what you were trying to get across is that you acted in self-defense in this passage.
Yes, I wasn't trying to get it across, but yes.
That's what you thought you were communicating.
No, I didn't think I was communicating that necessarily.
No, because actually what you say right after that is, why would you want my DNA? Was it for the saliva for the resuscitation? That's what you say next, correct?
Yes, I'm just trying to figure out what's going on.
You were trying to give the impression that the only reason that your DNA would be on Mr. Redlick is because you tried to save him. That's the impression you were trying to give.
I wasn't trying to give any impressions. I was trying to get some impressions. I was curious as to what was happening.
You were trying to throw her off the scent, possibly.
Do what now?
You were trying to throw her off the scent. You were trying to give her the impression that you were not involved in this crime, correct?
I don't know if I was trying to give her any impression. I just hadn't been able to tell my story.
Yep. Let's listen to another piece of audio, Ms. Redlick. If we go back in time just a little bit, you reached out to Detective Ware, and you got a call back from her. Yes?
Yes,
And this was on the 13th of 2018 in January.
I think so, yes.
You had been in the Bake Rack facility,
Yes.
and they came to you and they gave you the phone. Yes?
No.
Well, you got on the phone, right?
Oh, I thought you meant my phone.
You were on the phone with Detective Ware.
Yes.
Okay, let's listen to a portion of what's in evidence as States 40.
to name it, and I saw news a brief story saying a suspicious death had occurred, and so I don't know that, I mean, I know that rules at the same time. What are you telling people? And I was, how do we move forward on this if you would like to? That's really up to you. Now if you, I reported to the dispatcher when I called what happened, so
Did you hear yourself tell Detective Ware in that phone call, I reported to the dispatcher what had happened when I called? You heard yourself say that, correct?
Yes, that
It's all, that's my only question at the moment. When you told Detective Ware that you already gave your story to the dispatcher, you wanted Detective Ware to believe that you had told the truth to the dispatcher, correct?
that absolutely wasn't the full story. So
No. Answer my question. You wanted Detective Ware to believe that you had told the truth to the dispatcher, correct?
yes,
And because if she had believed that you told the truth to the dispatcher, you wouldn't be sitting where you're sitting right now, correct?
Objection, calls for speculation.
Thing.
no, I asked if I could move.
Please don't answer.
Oh, I'm sorry. Didn't know that.
Okay, let's keep playing.
I wonder if you guys were just looking into it from there and then finding, I guess I'm just looking what to do here. Because, things get done and I just don't want people thinking, the wrong things or whatever. Right, so what you saw on the news is the only thing that we released to the media. Nothing else is going to be released.
You didn't want people thinking that you had taken your husband's life, correct?
I had not been able to tell the whole story yet. So
You didn't want people thinking that you had taken your husband's life,
I
correct?
murdered my husband, correct?
Let's go to the 11-minute mark of this conversation.
501-1302. 1302. And I was told that you were the one that informed the children about their dad. So I was not the one. My sergeant was there, and also the Victim Service Center. A lady from the Victim Service Center in Orange County, she actually did the notification to the children. Okay. So do you know what they were told? They were just told that your husband had passed away and that you were in the hospital. And that was it. And so no one asked how? No. Okay. And even if they did, we wouldn't have given them that information. Okay, so that's just not being released yet for you guys further to determine on your end, is that correct? Correct, that won't be released. Okay. All right, do you have any other advice or direction for me at this point? No, just if you have any other questions, you are more than willing to reach out and contact me. And I'll get back to you. Well, I'm willing to talk. I just want to make sure that that's okay. Right, I'm not opposed to it at all. I told everybody the story here. And I guess yesterday I was just filling up with, just not knowing. These situations are pretty, not perfect clarity when you're dealing with them. Right. So, yeah, I might just call. I would call that and then perhaps I give you a call back and explain to you what I explained to everyone else for it. I don't know if you have access to those reports or not, but.
Ms. Redlick, you just heard yourself tell Detective Ware, I'm willing to talk. I've already told other people in here what happened, correct? You heard yourself say that.
Yes, I did.
And then you went on to say, perhaps I'll give you a call back and explain to you what I've explained to everyone else. You heard yourself say that, correct?
I think I heard that.
You want to hear it again?
No, it's okay.
Well, if you doubt it, I'll play it again.
No, I don't doubt it. It's okay.
So did you say that?
Yes.
One of the people that you've told your story to in the Baker Act facility is Frederick Copeland, correct?
I think he overheard what I was telling. I might have told him bits and pieces, yes.
The story you told Mr. Copeland was that Mr. Redlick stabbed himself, correct?
He says that I did, then maybe I did. I don't remember saying that.
You told Mr. Copeland that Michael Redlick had stabbed himself, correct?
Yes,
You lied to Mr. Copeland.
yes.
You wanted Mr. Copeland to believe you.
I don't know that it mattered what Mr. Copeland thought at that point to me.
Well, you actually suggest to Detective Ware, hey, you should go talk to the people I've already talked to in here because I've told them the story, right?
I think I was just referring to, you know, I hadn't got to the full story yet.
Miss Redlick,
Yes,
you tell Frederick Copeland a lie about what happened, right?
Objection, asked and answered.
You invite Detective Ware to come interview one of the people who you lied to, correct?
okay, yes,
Because you wanted Detective Ware to hear the lie you had told.
I think I was wanting her to talk to me, or I was ready to talk, period.
I'm not talking about you, Miss Redlick. I'm talking about you wanted Detective Ware to hear the lie you had told Frederick Copeland.
No, I wanted her to hear from me.
Do you dispute that you didn't invite her to go talk to the people you've already talked to?
I know I said that. I think I was just saying that I was prepared to talk, that I'm, you know, that's something that I want to do. So,
Another person that you spoke to in the facility was Carolyn Tucker, correct?
yes,
And you gave Miss Tucker a detailed account of what happened, right?
I would say yes.
And you told Miss Tucker about the Sam Katie comment, correct?
I did.
So, and you actually told Miss Tucker that Michael said the comment Sam Katie more than once.
Her details were very.
No,
off in
you're
my
not. You're
recollection.
not here to comment on another witness. You're here to answer questions, Miss Redlick. Did you tell Miss Tucker that Michael Redlick had made this Sam Katie comment on more than one occasion?
No,
You told Miss Tucker that Michael had come to the bathroom door and yelled Sam Katie, didn't you?
no,
Well, you told the jury on direct that Mr. Redlick had said Sam Katie once, right?
yes,
And that would have been, well, you're still at the breakfast nook,
right,
before he takes a bite of the hamburger.
yes,
Let's talk about Sam Katie, Miss Redlick. Are you saying that this is from the movie Cape Fear?
yes,
And this is a movie that you watched a little less than 3 weeks before you took your husband's life.
yes,
And you told this jury that Michael Redlick is standing before you and he is saying Sam Katie, which is a name, right?
yes,
And he's saying it at you.
yes,
And you told this jury that he's saying, and he only said it once, right?
I think it was just once, yes,
And you told this jury that Sam Katie is the bad guy in the movie.
yes.
Miss Redlick, there's no character named Sam Katie in Cape Fear, is there?
Objection, counsel testifying.
I thought there was.
Would you're not sure? You can't remember?
Now that the way you're asking me, I'm not sure, but I thought I was sure.
Okay, so you're not sure. Would looking at a page from IMDb maybe help refresh your recollection?
What's IMDb?
You know, where they have the cast and crew of a movie. You think that would refresh your recollection of whether that character exists?
Okay,
You think?
yes,
printout from Cape Fear IMDb,
Mhm.
and I'm going to go to the second or third page. And who did you say played Sam Cady?
Robert De Niro?
Okay. I want you to look at the name of Robert De Niro's character,
Max Cady.
and I want you to look at the name of Nick Nolte's character.
Sam Bowden.
Okay. So there is no Sam Cady in this record, correct?
I guess I got the name mixed up.
You got the name mixed up.
Yes. Said it, and I just recall that being it.
Are you sure this really happened?
Yes.
Cape Fear isn't about a man who's terrorizing two women, is it? It's actually about a convict who is trying to punish the lawyer who didn't get him off.
Right, which entails terrorizing his wife.
You told Miss Tucker that you did not call 911 because you couldn't find your phone, correct?
Yes.
That was a lie.
Yes.
You told Miss Tucker that Michael took the knife from your hand. That was a lie.
I don't believe I said that.
Well, you told Miss Tucker that he made a stabbing motion toward himself, correct?
He said, "What are you going to stab me?" That's what I believe I told her.
And you told her something. If that was an exact quote, you gave Miss Redlick the impression that Mr. Redlick disarmed you and had the knife, correct?
Yes.
And that was a lie.
Yes.
Lie to Miss Tucker, did they?
No,
You chose to lie.
I lied.
You chose to lie.
Yes.
You lied to Marcia Inglis.
No, I never spoke to Marsha Inglis from the hospital.
But Marcia Inglis overheard your statement, right?
Which one?
The one where you called and you said that your husband died of a heart attack?
I didn't say that. Said I'm waiting on the autopsy report, which wasn't released for weeks until I was actually after I was arrested. I still didn't know exactly.
Okay. Miss Redlick, you were willing to lie if you think it'll serve your interests, correct?
No,
Well, you thought it served your interests to lie to the folks that we've talked about thus far, right?
I think it served my interest of being confused and not knowing how to handle the situation.
The lie was serving your interests. You admit that.
Yes.
So you were willing to lie if it serves your interests.
Yes.
You lied to the ER doctor, or did you not?
Oh no.
Did you tell the truth to the ER doctor?
I don't remember speaking to the ER doctor.
That's Michael Redlick, right?
Yes.
Let's talk about the 911 call, Miss Redlick. It has been 11 hours since he's been moved from that location, correct?
I'm sorry, what?
When you pick up the phone to dial 911, it has been 11 hours since Mr. Redlick has been moved from that location,
Yes.
except when you're taking his shirt off, right?
Yes.
And mopping around him.
Right.
And moving his arm to clean under it.
Yes.
Other than that, he hasn't moved
Yes.
for 11 hours. Yes?
Yes.
You had had nearly half a day to figure out what you were going to say on the 911 call.
Objection, Judge, can we approach?
Ms. Redlick, you've had nearly half a day to figure out what to say, correct?
Yes.
And you are standing in the home with that man in that position when you finally pick up the phone, correct?
Yes.
And you know he's dead. There's no question. You know he's dead.
Yes.
Publishing what's in evidence is states 32. So that's the first dispatcher you talked to, right?
Okay, yes.
You talked to two dispatchers, right?
I didn't know that I did.
Well, do you want to listen to confirm?
No, it's okay.
No, it's important. So if you're not sure, let's confirm.
No, I talked to two dispatchers.
So you do know that.
Okay, yes.
So that's the first dispatcher you speak to, right?
Yes.
And you tell the first dispatcher that you speak to, quote, "I think my husband is deceased," end quote, right?
Yes.
That's a lie. You knew he was deceased.
Okay, yes.
That was a lie. Yes?
I said I think.
Yes, you said "I think" when you knew.
It's probably just an excited utterance. Yes, I knew. Of course I knew.
Of course you knew. Yep.
1231 Temple Drive, Water Park. Yes, okay, you know what, my jurisdiction, let me just, verify the phone on the line, hold on one moment. Water Park, no, what do you need to be fire medical? This is the water medical transfer for 1231 Temple Drive in Water Park. I 1231 Temple Drive, right? Yes, sir. Okay, thank you. What's going on at 1231 Temple Drive? I believe my husband is deceased.
Now you've told a second 911 operator, "I believe my husband is deceased." You heard yourself say that?
Yes, I did.
You knew your husband was deceased, didn't you?
I did.
So you lied to that 911 operator.
It was just a figure of speech.
It is a false impression, isn't it?
I can't answer that. I don't know what the person thought.
No, you were giving a false impression that you have some confusion about the state of your husband's.
No, I don't think that was in my head at all.
If I believe he was here. Because we've been, I just, he's sick, and he's really, he might have a heart attack, I don't know.
Okay. You were asked why, and you say he's stiff, he's wounded, he might have had a heart attack. I don't know. You heard yourself say that, right? You did not believe that your husband had a heart attack, Ms. Redlick.
Actually, I did. I was hoping too.
You were hoping.
Not in the morbid sense that I wanted him dead, but he had heart problems, and I thought with all of that excitement that perhaps he did.
So, because if you had a heart attack, you wouldn't have been responsible for his death.
Yes, to an extent.
But you knew he hadn't had a heart attack. You knew it.
Objection asked and answered.
I could not completely rule that out.
Standing there, having mopped up all that blood, taking all these towels that are stuffed in his bag, soaked them through with Michael's blood. You thought that it was possible he had died of a heart attack.
Thought there was a possibility. It was very quick, and I just wasn't.
No, actually, nothing last night. It happened last night? Correct. Okay. $65. Okay, we're back through. This morning, because I know you said that you believe it happened last night. Did you see him last night? Was he okay or was? He was not okay last night. We had altercations and to have himself and I ran.
So you were asked what happened, and you explained we had an altercation and he stabbed himself. This was a lie, Ms. Redlick.
Yes,
And you wanted this 911 operator to believe your lie, correct?
yes,
It came out, I had to help him and I told him this why, what? And you say, I had to ask help out, and then right, yes. All right, and then I tried to help him.
You were asked again. You say he stabbed himself. In your response, correct, yes. You heard yourself say that?
yes,
That was a lie too.
yes,
So you've lied now twice.
yes.
And I woke up sitting up next to him, and I'm trying to figure out what to do. Right. I got you, I'm gonna get you some help, You all had an altercation last night, correct? Yeah. All right. What's your name? Are there any weapons on scene now? A knife. He said he was 64, right? 65. I'm sorry? 65. 65. So, okay. Go ahead and give me your birthday with you, because I want to call you names. Danielle? Danielle. Okay, so Danielle, let me ask you this. So did he stab himself last night? Did he pass last night? And you just didn't know what to do? Correct, I believe so.
For a third time in this call, you have said that Michael stabbed himself, correct?
Yes,
And this is the third time you've lied.
yes,
You want this 911 operator to believe this lie, correct?
yes,
Were you all drinking? You are? Yes, you were. And the officer was 942, but I left the house. And took my phone with me, because he was dancing then too. Were your kids there last night during this altercation? No, they were not. They were not here, and they're not here now. I know you first said that you thought he had a heart attack. So do you think it was a heart attack, or do you think it was due to the fact that he passed away? Probably the stabbing triggered it, I guess. I don't know. It's a shoulder wound. You say it's a shoulder wound? Right. I'm just getting all this information. Okay. told me is gonna call, okay, I have multiple units in the house, I have to get by. Okay, give me your husband's first name. Michael, what's the last name? R-E-D-L-I-C-K. What is his name, paper? 5153. Yeah, right now, right? Take your silver and I'll take it over. Okay. No, we're not. Can you go ahead and move that knife away? So my unit will be able to get in there. Are you able to put that? Where's the knife? In the kitchen. Okay. R-E-D-L-I-C-K. Go ahead and verify your phone number for me. 901-355-1434. And what time do you think you are having our altercation and your staff and stuff? I think it started around 10:30. He was actually choking me and trying to suffocate me first. I actually went for the knife. And he was screaming out, "Are we gonna do this? Did we get your staff?" And he grabbed it.
To the 911 operator, you told her that Mr. Redlick choked you, didn't you?
I think I said choked, yes.
You said choked.
Yes.
You have not testified to this jury that you've been choked by
No.
Mr. Redlick.
No.
So that was a lie.
Wrong choice of word, yes.
Not the truth.
No.
So therefore a lie.
Wrong choice of word.
Let's back it up a little bit.
Are we gonna do this? Did we get your staff? And he grabbed it. And that's when he did it in emotion and I ran out of the room.
You heard yourself say that he grabbed it, correct?
Yes.
That was a lie.
Yes.
And because the knife was never in his hand.
No.
And when you said he made a motion, that was a lie.
I felt like he made a motion where you're going to stab me.
Is that what you were communicating there, Ms. Redlick?
I thought I was.
No, Ms. Redlick, you know that you were saying.
Objection,
He had the knife in his
argumentative,
hand.
objection, argumentative.
Sustained, rephrase your question.
Ms. Redlick, when you said he grabbed it and he made a motion, you were describing Mr. Redlick with the knife in his hand making a motion towards himself, correct?
At that point, yes.
And that's a lie.
Yes.
That's a detailed lie, correct?
Okay.
Yes?
Yes.
You are making up specific details to build out this lie, are you not?
I think I'm mixing some of the truth with some of the false.
Oh, so you're mixing truth and false.
Yes.
I want to focus on the false.
Okay.
You are creating details that are not real to make this lie more convincing, correct?
No, I just don't know what to say. I wasn't prepared to answer yes the way I should have.
Ms. Redlick, you are willing to make up specific and detailed lies when they serve your interests, are you not?
willing. I guess in this instance, I did do that, yes.
You are willing to make specific and detailed lies if you believe it will serve your interests, correct?
In that instance, yes.
You had hoped that this 911 operator and anyone who heard this recording would have believed those specific and detailed lies you told,
No,
correct?
I don't think I was thinking that intensely about it in terms of people believing it at that point. The situation was an entire mess, and I knew that.
10:30 p.m. And we need to go back to the second one where did you stay there? No, I stayed in the bathroom for a while. He came to the bathroom door and was still closed and he was doing stuff. I was just trying to get away from him and I heard some moaning and stuff and I was scared that Bobby went to check on him. And I could see that he was out of it. And I'm looking at his blood and it was the heavily bloody. So I tried to. I was like, he was already. I was trying to give him mouth to mouth. Is there a reason why you didn't call last night? Yeah, and we were playing and he guys like believe me. I was just trying to get him to wake up.
You told the 911 operator that the reason why you didn't call was because you were too busy trying to wake him up, correct?
Yes.
That was a lie.
Wait, what?
The reason why you didn't call 911 was because you were too busy trying to wake Michael up.
And I wasn't sure if people would believe me. Like I said.
And I was off after I fell asleep sitting on next to him. He tried to hurt myself this morning. It doesn't look good. The emergency people are here. Okay. So go ahead now. Okay. Go ahead. He's drinking stuff. I was just trying to get him to wake up. And I was exhausted after I fell asleep sitting on next to him. He tried to hurt myself this morning. It doesn't look good.
You said at the end of that call, before you noticed police and fire out front, it doesn't look good for me.
Yes.
And that's the truth, Ms. Redlick. It doesn't look good.
Objection argumentative.
Sustained, rephrase your question.
I have no further questions of this witness.
Right. Council approach.
Hi, Ms. Redlick. On December 18th, when you sent the email to your husband, did you attack him that day?
December 18th.
December 18th of 2018, you saw the email that Mr. Wiggins had started with. Do you recall what I'm asking about?
No,
Did you attack him that day?
no,
Did you stab him that day over an email?
no,
The state attorney had asked about a Mr. Barker that you spoke with in regards to the case, another attorney, not myself.
Yeah.
Is that a person that visited you to talk about the case?
yes.
When was that? If you don't know the day, but roughly when was that?
Right after, very beginning of the arrest, or right after the arrest?
It was after you were arrested?
Yes,
So while you were in jail?
yes,
Spoke about attempting CPR, mouth to mouth,
yes.
on Michael after you found him.
Mhm.
During that time, during that attempt, did it become clear to you at that point that your husband was dead?
Yes.
How did it become clear to you at that point that he was dead?
It was largely clear to me before that. However, he still wasn't moving or responding or anything, breathing.
When you called 911 the first time, was it clear to you that he was dead at that point?
Yes,
Nothing changed. You never at any point unbelieved that he
No.
was dead.
Objection, leading.
I'll rephrase, Judge. Did you ever change your opinion that you believed he was dead?
no,
State attorney showed you the phone activity in the timeline report. Not sure where it is over here, but you recall that? Showing what you were searching for online?
yeah,
Do you recall that night ever searching for how to clean up blood?
no,
Do you recall that night ever searching for how to clean up a crime scene?
no,
Do you recall that night ever searching for how to dispose of evidence?
no,
Do you recall that night ever searching for how to get rid of evidence?
no,
Do you recall that night ever searching for tampering with a crime scene?
no,
From you in your home.
Objection beyond the scope of direction of cross.
Is there a lake across the street from your home?
Objection.
Judge, may I answer that? May I answer that? May I respond to that? Do we need to approach? So, Ms. Redlick, the question is there a lake across from your house?
there is,
Did you at any point ever go throw anything into that lake?
no,
Did you leave and take anything from the house anywhere between the time that you arrived home, had the altercation with your husband, and the police arrived?
no, I didn't.
Did you look up anything about the laws of murder or self-defense or homicide or anything like that that night?
No,
Did you know any of those laws prior to being arrested?
Objection beyond the scope of cross.
Abstain.
In the 911 call, you referenced choking, and Mr. Wiggins had asked you about that, and you had used the phrase, I believe what you said a moment ago was wrong choice of words, correct?
yes.
What do you mean by that?
Should have said smothering.
Well, why would you say smoking, or I'm sorry, choking or smothering? What had happened to make you say those words, to choose those words?
She's choking.
Or smothering?
I think smothering is more in lines of what was happening.
Mr. Wiggins had asked you several times if you thought that your husband had died of a heart attack. Seeing it, and then again asked you, did he die of a heart attack? Is that a yes?
Objection leading, Your Honor.
Said he asked me.
No, stop. Sustained. Rephrase your question.
Ms. Redlick, did you think that the wound to your husband's shoulder was enough to kill him?
Objection asked and answered in direct.
Overruled.
No,
Why not?
it seemed to be a shoulder wound. I just not something that I would associate with someone dying from.
State attorney had asked you multiple times so I'm explaining the question and where I get to my question. Several times if you were willing to lie to serve your own ends. You willing to lie in court after taking the oath?
Objection, improper bolstering. Move to strike.
Sustained, and it will be stricken. The jury is to disregard that. The next question, Mr.
Judge, may I respond to that?
I've made my ruling. I'm not changing it. Ask your next question.
I have no further questions.
For the morning, the deputy will escort you out. You have your notebooks there, and be mindful not to talk about the case while you are out on break. Scheduling update. We have one witness who will be testifying virtually, and that witness is not available until noon. My understanding is that it won't be a long direct and cross-examination and redirect. So we're going to work through the morning. It's 11:15 now, so we'll work through the morning. And then at noon, we won't break for lunch right then. We'll have the witness appear virtually. And after that witness's testimony is done, then we will take our lunch break. And it'll still be for the hour and a half, but it's just not going to be at noon. Okay. Ms. Conlon.
Yes, at this time, defense calls Dr. Sarah Zadovich. You solemnly swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth.
Ms. Conlon.
Thank you. Doctor, as part of the autopsy, did you have toxicology testing done on Michael Redlick?
Yes,
And you did this on his blood, is that right?
blood, yes.
Did it show if Michael Redlick had consumed alcohol prior to his death?
Yes.
How much?
I can't tell you exact amount, but the blood alcohol concentration was 0.90 decibels per liter, per milliliters.
And that's above the legal limit to drive, right?
Yes.
Now, caffeine also showed up on the toxicology, is that right?
Yes.
But it did not quantify how much.
Correct.
And supplements can contain caffeine.
Yes.
The testing done in this case did not test for testosterone,
Yeah, it did not.
but additional testing is available for testosterone.
There can be testing done for that. Yes.
No further questions.
Garcia?
Yes, Your Honor. Now, the alcohol, that didn't affect the cause or manner of death, correct?
Correct.
And the caffeine, that didn't affect the cause and manner of death either, correct?
Correct.
And there was nothing else in Michael's system, correct?
Correct.
Nothing further, Your Honor.
Thank you. Can you redirect?
No, Your Honor.
Thank you very much, doctor. You may step in. Present your next witness, please.
Jennifer Brown.
Do you solemnly swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes.
Ms. Brown, would you please state your full name for the record? Spell your first and last name.
Yes, Jennifer Brown, JENNIFER BROWN.
Ms. Conlon.
Thank you. Ms. Brown, what is your occupation?
I'm a registered nurse.
And do you know Danielle Redlick?
I do.
How do you know Danielle Redlick?
I know Danielle through our sons being friends.
What are the names of your sons?
My son is Brian, her son's Sawyer.
Are they friends?
Currently, they haven't talked.
But at the time of 2019, were they friends?
Yes.
How long have you known Danielle?
Since the boys were in first grade together, so that would be approximately 7 years, 8 years.
What would be the reason? Did you have a chance to see Danielle during those 7 or 8 years when your boys were friends?
Yes.
And what was the reason that you would see Danielle?
When I would drop my son off to hang out with her son at their house or for a sleepover, things like that.
Ms. Brown, have you ever observed any injuries to Danielle?
Yes, one time.
And when was that?
That was in the spring of 2018. Can't recall which month, but sometime in the spring between March and in May.
So let's get back to what you observed. Where were you and Danielle when you observed this injury?
She had come to my house to come pick up my son Brian for the day. She was going to take him and her son Sawyer to go do something for the day.
And what did you observe?
I observed a large black and blue eye.
So what was Danielle Redlick wearing when she first came to your house?
I don't remember her clothing attire, but I do remember that she was wearing a ball cap and sunglasses.
So did you immediately see this black and blue eye?
Not immediately.
And then how did you, what were the circumstances that led you to see this black and blue eye?
So she had pulled up in the driveway. She walked up to the front door. We had conversation at the front door for some time. And then I walked her and my son back out to the car, and she slipped off her sunglasses briefly, and I happened to just see it. It was obvious.
What was your reaction when you saw the black and blue eye?
Objection relevance.
Ms. Kane.
Did it appear to you as if Ms. Redlick realized that she had taken off her sunglasses?
I don't believe so.
Did Ms. Redlick tell you how she got that injury?
She did not.
Nothing further.
Mr. Wiggins?
You have known the Redlick family for, at least as of July of 2019, for about 6 years, correct?
Correct.
And at no point during those 6 years did Miss Redlick ever tell you that Michael had been physically abusive with her.
Correct.
However, in the last 2 or 3 years of knowing Danielle and Michael, Miss Redlick would start to talk about Mike in a more negative way.
Correct.
One of the things that she would bring up to you was that Mike was very controlling with the money.
She mentioned it a few times.
And that was a problem for Miss Redlick.
It seemed.
I have no further questions at this point.
Redirect?
No, Your Honor.
Defense, your next. Defense calls Gregory Miller. Do you solemnly swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Good morning, Mr. Miller. Would you please state your full name for the record and spell your first and last name?
Gregory Lewis Miller, GREGORYMILLER.
Ms. Conlon.
Thank you. Back in January of 2019, where were you employed?
ABC Fine Wine and Spirits,
And what was your position there?
Corporate Asset Protection Manager.
What were your job duties?
Day-to-day operations for asset protection, reports, things like that.
Was part of your job duties to provide surveillance videos at various ABC liquor stores to law enforcement?
It was.
I should let the record reflect I'm showing the state was remarked as defense exhibit J. Can I approach the witness?
Yes, ma'am.
I do.
And how do you recognize it?
It was shown to me prior to trial that it was going to be administered as evidentiary.
Have you had an opportunity to review what's on this USB?
I have.
Is this USB a fair and accurate copy of a video from the ABC store number 8?
It is.
And what was do you remember the address of store number 8?
I don't recall the exact address. No, I don't. It's Winter Park. I know that much.
Was it the 1425 Howell Branch Road?
That sounds correct.
And is this a true and correct copy of the video maintained by your company during the relevant time period
It is.
from January of 2019?
Correct.
On January 11th of 2019?
Correct. I believe so.
So this video of store number 8 is a true and correct copy from January 11th, 2019. Is that right?
It is.
Was this video made at or near the time of January 11th, 2019?
I believe it was after the fact. I was contacted, and so yeah, I believe it was. I don't know how far in between, but yeah, the video was pulled from the DVRs from that location.
Okay. And was this video created and kept in the course of regularly conducted activities of ABC Liquor?
It was.
And was the video equipment regularly maintained and in working order at the time of this event?
It was.
And was the video made as a regular practice in the course of the regularly conducted activity of ABC?
Yes.
No further questions.
Cross-examination?
No, Your Honor.
Defense calls Detective Ware.
Do you solemnly swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Ms. Conlon?
Detective Ware, did you have an opportunity to interview Jaden Redlick?
I did.
And did you talk to Jaden Redlick on January 12th, 2019?
Yes, I did.
Did Jaden tell you that?
Objection, hearsay.
Your Honor, can we approach?
as soon as I finish. Has exited.
Look at the case in which I cited on page 8.
And this is Pierce.
And Pierce, yes, Your Honor. So before a witness can be impeached with a prior inconsistent statement, a proper foundation must be laid. The prior to questioning a witness about the contents of a previous inconsistent statement, counsel must call the witness's attention to the time, the place, and the person to whom the statement was allegedly made. Your Honor, none of this was done in this particular case. The case goes on to assert, and the rule in which I provided behind that, which counsel herself cited, states that extrinsic evidence, which counsel is trying to do here, is only admissible if the proper foundation is laid. Jaden was never given an opportunity in order to properly either admit or deny the statement. She was never impeached, Your Honor. Counsel said what she was using it for her recollection. So when we went sidebar, she said that she was doing the recording to refresh her recollection. She let Jaden, the witness, listen to the recording. She asked no questions about whether or not that recording refreshed the witness's recollection or not. And then counsel proceeded to ask her next question. After she got the answer, she sat down and asked no further questions. She did not start in on the formal impeachment. And per the rule and per this case in case law, she is required to do that before she can admit extrinsic evidence, Judge, which is what she's trying to do right now.
Okay, Ms. Conlon, I'll hear from you.
Yes, so I don't know if the court has a copy of the Elmer v. State case.
I do.
Okay, so this is the one that I am referring to. I think it's very clear. My specific question was, it appeared to me that yesterday, or when Jaden testified, that she did not specifically, she was hesitant in whether or not she made that statement or not. So that is the reason why I first attempted to refresh her recollection. And
Did you ever ask her if her recollection had been refreshed?
I don't have the transcript in front of me.
Your counsel, I have a copy for you, no worries. At the end, so it would be, you finish up towards the end.
Page 129,
Is-
line 8 to 9.
Yes.
Was she ever given an opportunity to explain or deny making the statement?
well, she actually said that she did not make the statement.
That's what she said, but was she given an opportunity to admit it, to deny it, and then at that point be shown her prior inconsistent statement?
So she was given the opportunity when I asked her, Jaden, on January 11th, when you came back from school and your dad arrived, did you observe or hear your dad tell your mom that she better make up a good lie as to where she was? That was the opportunity to either admit, deny, or say, I do not remember.
She said, no, I did not hear that. And after that, did you continue on with the foundation under Rule 614 to impeach her on that prior inconsistent statement?
No, that's not in the transcript. I would,
So if it's not in the transcript, then that means she didn't do it. So Jaden was never given that opportunity to explain the answer that she gave. When she said no, there wasn't any follow-up after that.
so once a witness denies making the statement, I think that 90.6 614 would kick in, where I can use another witness to impeach that person's statement.
Is she saying that she doesn't remember it? She just said, no, I did not hear that. She's not saying she didn't remember it. She's just saying she didn't hear it, correct?
Right, but it's evident that when she tells detective that this is what she heard, what was said, that's an inconsistent statement.
Hold on. Where does the sidebar start? Is it 122?
Your Honor, it's a little bit, the sidebar starts at 122. Yes, Judge.
So she's asked the question, jog your memory. If you listen to the audio, I allowed her to listen to the audio.
But then she was never asked, did that jog your memory, Judge? Could you hear the audio? Has your memory been refreshed? Those questions were never asked of her. Literally, the audio was played, the jury was brought back in, and counsel proceeded to re-ask her initial question. So first, I would assert that she never really laid the proper foundation for refreshing the witness's recollection. So we don't even know if the witness's recollection had been properly refreshed to begin with, Judge. And then second, counsel absolutely did not go into the impeachment process at all, which is required per the rule and per case law, before she can now admit extrinsic evidence.
So I'm looking at 90.614. We start off with subsection 1. When a witness is examined concerning the witness's prior written statement or concerning an oral statement that has been reduced to writing, the court, on motion of the adverse party, shall order the statement to be shown to the witness or its contents disclosed to him or her. I would point out that there was no motion by adverse party to order that the statement be shown to the witness or its contents disclosed to him or her. In this case, the contents were actually disclosed to Jaden Redlick because we played the audio in her presence. Subsection 2 is what I'm arguing under, extrinsic evidence of a prior inconsistent statement. We now have an inconsistent statement where Jaden Redlick made an affirmative statement saying she did not hear something, when clearly she talked to police and said, this is what dad said to mom. So going forward with subsection 2, that the extrinsic evidence of a prior inconsistent statement by a witness is inadmissible unless the witness is first afforded an opportunity to explain or deny the prior statement. Here, Jaden Redlick denied making that statement. And according to Elmer v. State, once she denies it, or in the alternative, if she says, I don't remember, that is admissible at that point.
And Your Honor, the state would assert that she did not do that proper foundation. Jaden was never asked, nor was she afforded an opportunity to explain or deny the statement.
So I would point out that in Elmer v. State, if a witness cannot recall making the prior inconsistent statement, the fact that the statement was made may be proved by another witness. That is what is being done in this case. We're proving that statement through another witness.
Well, Judge, I'm going to stop right there. Are we going under a past reported recollection, or are we going under extrinsic evidence? Those are two completely different statutes with completely different rules, Judge.
I don't know.
This is under 90.614, extrinsic evidence.
Okay, so we're not going under the past reported recollection. So the extrinsic evidence specifically states that the witness, Your Honor, when we went sidebar, counsel specifically stated she was using this to do the reported to refresh the recollection. There was nothing about an impeachment. So then counsel didn't lay the proper foundation to even establish that the recollection had been refreshed before she asked the next question. So counsel wants to use this next question as, well, Judge, that next question is the one that I'm using as, yep, she had the opportunity to admit, deny, Yep, that was the next question, Judge.
Okay, y'all give me a minute to read what you said. Give me just a second. That Jaden made to Detective Ware is that I heard my dad tell my mom she better make up a good lie. Is that right, Ms. Conlon?
Yes,
And so that's the statement you're trying to get into evidence.
yes.
So what it looks like to me, when she was given that audio recording and that was played, she said she did not hear that. How is that not the end of the questioning? Okay. She was afforded an opportunity to explain or deny that. She was asked the question a second time by Ms. Conlon after the bench conference. She was asked the question. She said she didn't hear it. Then there was an opportunity for questions on that. There's something that's a little off here. Can I see that report that you're,
Which report, Judge?
the one that has her statement in it? Was it the
report?
I think it was. Because that's what you're impeaching her with? Is that what you're asking Detective Ware about?
It's the audio,
It's the audio.
because we played the audio, Judge.
Okay.
Yeah.
To explain the statement that she had made, which was that she had heard her father tell her mother, she better have a good lie. So she was given that opportunity, and she denied hearing that.
And Your Honor, the issue that the state has is we were under the premise of one thing, which was going to refresh her recollection.
Right.
And so what counsel is doing now, so when we were talking and when she was talking with Jaden, she was just trying to refresh her recollection. So now she's trying to say, I was trying to refresh her recollection, and now I'm using that for an impeachment. So what she should have done, Judge, is when Jaden said, no, I didn't hear that, the next statement was, well, don't you remember giving a statement to Detective Ware? And that's what we listened to. And didn't you say in that statement that this is that and the other? Those were the next questions. Counsel didn't ask those. In fact, she didn't even clarify once again with Jaden that she heard the recording or that the recording was correct, Judge. We are assuming all of that. All we have is that the recording was played. She reacted. Here's. They have to have the opportunity in order to be the inconsistent, must recall the witness's attention to the time, place, and the person to whom the statement was allegedly made. All of that foundation must be done, Judge. That was not done in this particular case. So counsel wants, because she was actually using the recording to refresh the recollection.
And it wasn't used.
And it wasn't.
In terms of
Impeachment.
impeachment.
That's
So
correct.
If you had a deposition transcript, then you would show them the deposition
Right.
transcript and then ask those lines of questioning about, I was there, you were there.
Exactly. And she should have, and
Mary.
counsel stopped short. She should have asked those additional questions.
So everything was eliminated as soon as I directly asked Jaden Redlick the question, did you hear your dad say, make this statement? As soon as she said, no, I did not hear that, that is enough. I don't need to go back and refresh her recollection. I can impeach her at that point with extrinsic evidence.
Yes, you can, if you go through that line of questioning to lay the proper foundation. The argument that I'm hearing is that from the state is that the proper foundation for impeaching her with that prior inconsistent statement has not been laid. That's my understanding of the state's argument. So if that's her argument, then my question to defense is, was the foundation laid? And I can see from the transcript that that part wasn't done. Come up right quick. So the objection is sustained for the reasons I stated at the bench conference. Let's bring the jury back in, please.
Did you attend the autopsy of Michael Redlick?
I did.
And was it Dr. Zadovich who conducted the autopsy?
It was.
Did you have a conversation with Dr. Zadovich?
I did.
And did she tell you,
Objection, hearsay.
Ms. Conlon?
may we approach?
Yes. The objection sustained.
Let the record reflect, I'm showing the state what's been pre-marked as Defense Exhibit J. May I approach the witness? Take a look at this. Do you recognize it?
Yes, ma'am.
And what is it?
It's a thumb drive containing a video for ABC Liquor.
Is this the video that you obtained from ABC Liquor in this case?
It's a copy of it, yes.
And is this the video that you had mentioned on direct or cross-examination before that you received from Gregory Miller?
That's correct.
And did you get the ABC video from Gregory Miller because he was the records custodian?
I did.
And this is the video that you had mentioned on before, that Michael Redlick purchasing vodka on the day of the incident, January 11th at 4:42.
That's correct.
And does it fairly and accurately depict, is it a fair and accurate copy of the video?
Yes, it is.
At this time, defense moves into evidence what's been pre-marked as Defense J.
Any objection?
No, Your Honor.
It is admitted as the next numbered exhibit for the defense.
Defense Exhibit 9.
Permission to publish.
Yes, ma'am.
are starting at 3517 to go to 3840. Do you see Michael Redlick in this video?
I do.
And which individual is he?
He's the gentleman behind, he's wearing jeans and a long sleeve shirt with a black t-shirt.
Can you, if you can turn around, is there any way you can point him out?
That's standing there behind the guy in the blue shirt.
Thank you. Is that Michael Redlick at the counter?
It is. Publishing 3545 to 3855. Do you think I'm going to forward through some of this? Was that Michael Redlick coming in and then we're going to see him go out pretty soon? Yes. I do.
What is it?
They're photos of a recyclable bin with some items inside.
Are they fair and accurate depictions of what you observed at the Redlick home on January 12th, 2019?
They are.
At this time, defense moves into evidence what's been pre-marked Defense Exhibit P.
Any objection?
No, Your Honor.
That will be admitted as the next numbered exhibit.
Defense Exhibit 10. Permission to publish?
Yes, ma'am. Before you do that, can you give that to Betsy so she can mark that, please?
Where, what is it that we are looking at?
That is a cabinet and it's a recyclable bin. It has a recyclable bin inside of the cabinet.
And this is inside the kitchen, right?
Yes, it's inside the kitchen of the Redlick home.
And this is just a close-up of that recycle bin.
It is just a close-up.
And what is this?
That's the inside when you open the drawer. That's the inside of the recyclable bin as all the items were inside.
And this is what was in the recycle bin on January 12th, 2019, is that right?
That's correct.
And this bottle right here, does that appear to look like the same bottle that Michael Redlick purchased?
Objection, speculation.
Sustained.
Do you know what this bottle is?
Yes, it's an empty bottle of a vodka. It's an empty vodka bottle. Yes. That's correct.
Do you have any cross-examination?
I do, Your Honor.
Let's do the cross. I understand. It's about the 12 o'clock witness?
That and something else.
Okay. That you would need to take up on your direct? I think he said yes. Ms. Garcia?
Good morning. I'm fine, thank you.
Watched a video of Mr. Redlick buying one bottle of alcohol, correct?
That's correct.
Your Honor, permission to publish what's been entered as 6 to the jury?
Defense 6 or state 6?
State 6, Judge. we go. Give me 1 second, let me focus in here. So Detective, this is a photo from the freezer in the Redlick house. Is that correct?
That's correct.
And this is a bottle of liquor. Isn't that correct?
That's correct.
The same bottle that was found taken out of the trash, correct?
Yes, same type of bottle.
The same brand, is that correct?
That's correct.
No further questions?
Ms. Conlon?
Other than what was discussed at the bench.
To clarify one thing,
Okay.
and it was a bottle of Tito's vodka, is that correct?
That's correct.
That was found in the freezer, correct?
Yes.
Nothing further, Judge.
Did you have any questions?
No, Your Honor.
Detective Ware, you can step down. Is Dr. Azur available now?
He should be on the way.
Welcome to an Econo meeting. You are entering the meeting now.
Good morning, Dr. Azur. This is Judge Wilson. Can you hear me?
Yes.
Okay. Could you please raise your right hand? The clerk is going to swear you in at this time.
Do you solemnly swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
Sir, would you please state your full name for the record, spelling your first and last name?
Frederick Martin Azar, Frederick. Last name Azar, Azar.
Ms. Conlon?
Dr. Azar, what is your occupation?
I'm an orthopedic surgeon.
Did you at one time in your career work with the Memphis Grizzlies?
Yes.
And what was your job with the Memphis Grizzlies?
I've been the team physician for the Memphis Grizzlies.
Did you know Michael Redlick?
Yes.
How did you know Michael Redlick?
He was an executive with the Memphis Grizzlies, and I came to know him when they started the team here in 2001.
Do you remember when you first met Michael Redlick?
I don't remember the exact moment. I just remembered it was in 2001.
Do you know how long Michael Redlick stayed with the Memphis Grizzlies?
I believe until 2008.
What was your relationship with Michael while he was working also with the Memphis Grizzlies?
It was a collegial, more of a business relationship, and it was also a patient-doctor relationship.
Did you know Danielle Redlick?
Yes,
How did you know her?
I met her through Michael.
As the team doctor for Memphis Grizzlies, did you treat and care for the people on the team and their families?
Ask your question again, please.
As the team doctor for the Memphis Grizzlies, did you treat and care for the people on the team and their families?
Yes,
Was there ever a time where you treated both Michael and Danielle Redlick at the same time?
I treated both of them. I'm not sure if I saw them on the exact date for anything that I have documented.
Well, was there an instance where both of them came to you to your office?
There was an instance I recall that was not documented where they both came to my office.
What were the circumstances of that visit?
I have a vague recollection of the visit, but I remember there had been what was apparent to be a domestic incident, and that both of them had sustained some injuries, and they came to me to get checked.
Can you repeat the part again, doctor?
And they came to me to get checked.
Did you get it?
Now, do you recall what injuries you observed on Danielle Redlick?
I do not recall anything specific. I think there may have been a facial injury. And the reason I recall that is I consulted with our team plastic surgeon. At least I recall consulting with him. And so I think it may have been something like that, but something that was not orthopedic. In other words, something that was not for me to treat.
Okay. Now, you said that she had facial injuries. Did you also refer her to a dentist?
I thought I did, but after after my deposition on this case, I corresponded with the dentist and the plastic surgeon. The dentist did not recall. Team dentist did not recall seeing her.
Okay. But you recall referring her to the plastic surgeon?
I vaguely recall referring her to the plastic surgeon, and he confirmed it when I spoke to him about it.
Okay. Did you learn the cause for the injuries?
I didn't get into what had happened. I think that they assumed I figured what had happened, and I didn't really get into it. I don't recall getting into it.
How were Danielle and Michael acting during this visit?
If I had to say one word, it would be ashamed. I don't recall more than they just felt ashamed and needed some help, and that was really the tone of the visit.
I have nothing further.
Mr. Wiggins?
Dr. Azar, you are unable to say when this particular visit occurred, correct?
That's correct.
So it could be at any point between 2001 and 2008.
Well, I first met her in 2003, I think, but I guess it could have been between those dates. Yeah,
So between 2003 and 2008, you can't be more specific than that.
it cannot be.
And there's no documentation of this visit.
It's not.
You recall that seeing bumps and bruises on Mr. Redlick on Michael?
I recall both of them having something, but yeah, nothing that I needed to evaluate or X-ray or treat.
It was nothing for an orthopedic surgeon or an orthopedic doctor to do.
I would have documented it, and it's just not documented in my records.
But to be clear, Michael had injuries when he presented to you.
Yes.
And when you say ashamed, that was the sense you got from both of them, that they both were presenting with this feeling of shame.
Look, I have really vague recollection of this meeting, but that's the tone. That's what I can remember.
And since your deposition, you have followed up with some records and some colleagues, and you've determined that there was no dental referral that resulted from this visit.
I made the 2 phone calls, and I didn't look at any records. The team dentist did not recall a visit from either one of them. But the surgeon did. I assumed you had records.
Doctor, we can't understand you. I have here that you made 2 phone calls. And what did you say after that?
I recall calling the team dentist. Did not have any recollection of seeing anybody related to this incident. And I called the plastic surgeon. He did recall seeing, I believe, Danielle.
So to confirm, you, by doing this follow-up, determined that there was not a dental issue from this follow-up, that you had sort of referred out.
That's correct.
Okay. I have no further questions of this witness.
Any redirect?
Your Honor.
Okay, thank you very much, doctor. You may be excused.
Thank you. Thank you.
We're going to take our lunch break now. Come back at 1:45.
against the wall. The defendant did not testify to this specific instance during her direct examination. The other one was about both this witness and the defendant coming home and the victim throwing a chair in the direction of the defendant. And so that was not testified to, Judge. And so, Your Honor, at this point in time, this witness coming on the stand and testifying to those specific instances, it's not relevant because at this point, the defendant hasn't made it relevant. She hasn't testified to those specific instances and how they impacted her and her mindset. So therefore, this witness testifying to them, it's not, she hasn't made them relevant at this point in time. The defendant in her testimony hasn't made this witness relevant in those specific instances, in those areas.
But isn't the whole theme of this trial how these two are involved in mutual combat on a regular basis? They have a volatile relationship. And we've heard about that in the defendant's testimony yesterday.
Absolutely. However, Your Honor, for the defendant, in order to make, because the defendant has testified to specific instances, and for those specific instances and those specific acts to be entered, the defendant herself has to make them relevant because she's the only one who can make them relevant. That these specific acts somehow impacted her and the course of her relationship with the victim. So what we have here is we have very specific acts which the defendant did not testify to. And now we're going to have an individual come in and testify that she observed these specific acts, even though the defendant hasn't indicated that they impacted her in any way, or how, and so the defendant hasn't made those specific facts relevant to her relationship to Michael, and the nature of the relationship.
Thank you. Mr. Conlon?
Yes. So we expect that Melanie Tenaglia is going to testify as to an instance in Memphis, Tennessee, where she comes in to the house, to the Redlick home, and she hears screaming. When she hears screaming, she starts walking towards it and walks into the master bedroom and then sees the two of them in the master closet. What she testified to in deposition was that she went into the master bedroom and Michael is standing there with his back to her. And then she was looking for them and her back was up against the wall in the closet and he was screaming in her face, calling her a name. So this is an actual physical act of aggression that a lay person observed. It corroborates Ms. Redlick's testimony in yesterday's direct testimony. And I'm quoting from the unofficial transcript. I don't have the page number, but it starts off at 103/211. And then it has.
What page?
I don't know the page, but it looks like the unofficial transcript has these side numbers of 103 and then slash and then another set of 3 numbers.
This was from yesterday's testimony?
Yes.
The transcript that I'm looking at doesn't go up that high. It goes up to 44. Where did we have paper? 103? Do you have 103? I did print.
Yeah, is this the time? Maybe this is the time.
103/211. Don't see a 211. I see 103-11. And this is testimony from yesterday afternoon?
Yes.
I don't see this location that you're talking about.
I'm going to get the page number, and then once I have the page number, I only have this
If you have one, yes, ma'am. If you don't mind, thank you.
No.
That's okay. Sorry, Bree.
It may have been in the morning.
So the afternoon isn't the right one. Is that right?
I think we had already moved past that point, so I don't believe the afternoon is the correct one. What I'm looking for, or what I saw, was where there were questions that were asked when Ms. Redlick was living in Tennessee, where the question was, were there other specific instances of physical that occurred while you were living in Tennessee? Answer, yes. There were times that, like I said, there was a lot of manhandling, trying to control things. I roar. I don't think that is correct. I don't think that part is correct, but there's a statement slamming me up against a wall quite a few times. So what we have is Ms. Redlick testifying that while she's in Tennessee, she was slammed up against a wall. And then
The closet wall, or is there another instance that she's referring to?
I'm not sure if in the transcript she actually said closet. What she said, from what I can tell here in the unofficial one, that it was wall.
Okay.
And Your Honor, I mean, I do have a case for Your Honor, just to cite for the record. It's Hedges versus State 667 Southern 2nd 420, which is a first DCA from 1996. And it says, before a defendant may offer this type of character evidence, a proper predicate must be laid by the evidence by some overt act on the victim's part, at or about the time of the incident, which reasonably indicated to the defendant the need to act in self-defense. It also talks about the victim's reputation of the violence or the specific prior acts of violence is admissible when the defendant knew of the victim's violent acts or of his violent reputation at the time of the alleged incident. Such evidence tends to show that the defendant acted in self-defense. So, Your Honor, the issue that the state has is because the defendant was testifying, and she never specifically talked about the closet and slamming against the wall. She talked about generalities, that there were multiple times in which she was pushed or, slammed against the wall, but she didn't talk about the specific instance in Tennessee where she was pushed against and slammed against the wall in the closet, Judge. And in order to use and bring out this type of character evidence, that is what is needed and required per the rule. It's not just that just because the defense is seeking and asserting self-defense, they get to then, bring out all types of different instances. It's only the instances in which the defendant used and relied upon in formulating this issue for the self-defense. So at this point in time, the defense and the defendant has not made this specific instance in the closet relevant. They haven't talked about that specific instance, Judge.
Okay. I'm reading the Hedges case, or at least Head Note 3, 4, 5, 6, and 7 in the Hedges case. Where the witness or where the defendant testified that he was slinging me against a wall, and that's what happened when they were in Memphis, that he was slinging her against the wall, and she was testifying in generalities about that. How is that not a sufficient predicate for these statements from this particular witness?
Well, because first, this particular witness is never going to say that she saw the defendant actually touch the defendant. So the testimony that this witness is going to give is she's going to say that she heard screaming. She goes into the closet. She sees Danielle back against the wall. The victim is not touching her at all, but just screaming at her. So this witness is not going to testify that the victim took her and threw her against the wall, Judge. It is merely that she was in the closet, back against the wall. According to the witness perceived that she did not have the ability to leave the closet, Judge. However, she's going to testify she never saw the victim's hands on the defendant. And that's the issue the state is having. It's not like this witness is going to be able to threw her up against the wall. So that's why we're saying that they haven't established this particular incident, because it's not an incident where this witness can testify that she actually saw the victim throwing the defendant against the wall.
Thank you, Ms. Garcia. Ms. Conlon, if what the witness saw was not a physically violent action, how then is this testimony relevant? Or how then is this testimony admissible to show violence or violent tendencies on behalf of the victim?
So just so that we're clear, this is not admitted for character evidence. This is admitted to show the reasonableness of the defendant's fear. And what we expect the witness to testify is that there was yelling, so we know that there was argument between the two. We know that we expect her to testify that Michael's back was to her, and what she observed was that Danielle's back was up against the wall. Michael was standing over her and screaming in her face, calling her a derogatory name. So that is because of her viewpoint, she wasn't able to see the actual pinning, but what she can testify to is that Michael Redlick was up against her so that Danielle Redlick had nowhere to move. Her back was against the wall, which is what Ms. Redlick testified to as far as manhandling. There'd be instances of manhandling. He would pin me to the wall. He would, so I think with pinning to the wall, there's an implication that her back would be up against the wall. And just because the witness's viewpoint couldn't see the actual Michael Redlick's hands on her, we still have testimony that this was an aggressive situation. It was volatile. Michael Redlick was standing over her and yelling at her, calling her a...
When did this event in Memphis happen? Do you remember the timeline on that?
It would have been when they were living in Memphis.
Here's my ruling and based on my understanding. This act in Memphis isn't at or near the time of the defendant's stabbing of the victim in self-defense. I think it's too remote in time. In addition to that, I don't feel that the testimony that we have right now before us from the defendant, like I said, it's broad in nature in terms of he was slinging me against the wall. It's not this specific type of conduct, meaning it's not being... In Memphis, we had an argument and he pinned me against the closet. And then this testimony from this witness could corroborate that because this is what she saw. But even more problematic is that this was not something that happened. This event that the witness would testify to is not something that happened at or near the time the defendant claims to use self-defense to protect herself. So I'm not going to allow this particular witness to testify regarding those specific acts of aggression for those reasons. Is there any other witness that you have issue with?
No, Your Honor.
Defense, do you have any other issues I need to take up before they bring?
You'd see video, but can we also have an opportunity to proffer this aspect of Melanie Tenaglia's testimony?
Yes.
And I just wanted to check.
Interested briefly on that argument in regards to Ms. Teneglia, because I want to make sure that the understanding of the case law upon which the state attorney is relying is clear. I believe, and I understand the court's rule, I just want to make sure we're all on the same page. When the Hedges case references an overt act that causes the defendant to be acting in self-defense, that's referencing the offense for which she is charged currently. So the prior acts are not relevant until we have established an overt act by the alleged victim, in this case, that makes her fear of him relevant. I think everybody would agree that that has been established. I don't think that there needs to be specific testimony in regards to an overt act for the prior offense to make that relevant. That doesn't, if the court's ruling it out on timeline, then that's a separate issue. But I just want to make sure, based on the way the court worded the ruling, that I think that that's not correctly applying the Hedges language.
Because the overt act only involves what happened in the instant case. Is that what you're saying?
Right. So the relevance becomes the overt act that makes Ms. Redlick feel she needs to act to defend herself occurring has been testified to. That is Michael Redlick attacking her in the kitchen in January of 2019. Because that has been testified to, prior acts of violence against her by her husband become relevant if they establish fear or the need to protect herself in her mind for the current case. The defendant does not have to establish or give specifics to the point that the state is asking for on the actual prior acts to make them admissible in this hearing, in this trial. Again, the court's making a decision based on remoteness. That's not something that I'm arguing with. Just that the overt act language from that Hedges case is referring to the act that she's currently on trial for, not the act in Memphis.
And Judge, the one thing I will say is that the defense does have to establish that the defendant was in fear, which is one thing we don't have here. Because if she doesn't testify to that specific instant, then we don't know how it affected her. And so we don't know that she was in fear and that that was an instant that, you know, caused her to be in fear that then led to this overarching, you know, the overarching issue. And that's what the record is lacking, is there's no indication from the defendant how this particular incident affected her at all. We're silent on that.
May I respond to that about the fear?
Yes.
Okay, so Ms. Redlick has already testified that on the night of the incident that she was in fear. This so that is what Ms. Redlick has to testify to in order to make the prior incident relevant, because it goes to the reasonableness of her fear. These past incidents inform whether or not her fear is reasonable. So because of these past instances where she was being manhandled, and then there's an overt act on the night of the incident that caused her to have fear, now the prior incident becomes relevant for the reasonableness of fear. And
Even though it happened when they lived in Memphis and not something that happened when they were living here in Winter Park?
yes. So there's another case. The reason why is because the prior acts of violence, even if it didn't need to happen while they were living in Orlando, Winter Park. They just had, but even if it was 3 years, 5 years, 7 years, if it's, especially since it's ongoing, the fear that she had because she knows the reason why is because the prior acts of violence, even if it didn't need to happen while they were living in Orlando, Winter Park. They just had, but even if it was 3 years, 5 years, 7 years, if it's, especially since it's ongoing, the fear that she had because she knows how her husband has manhandled her or abused her, those instances are relevant to inform like the reasonableness of her fear, even if it occurs 7 years later or 5 years later or whatever it might be.
Okay. I still stand by my previous ruling. It's not going to be admitted, or that witness will not be testifying regarding that prior instance.
And then, Your Honor, I just want to clarify with defense, we had chatted earlier that she wasn't going to go into the other instance in Tennessee. Is that correct?
Right.
Okay.
Anything else?
So I didn't know when the court wanted to proffer because
We can do that now, since she's here.
outside the presence of the jury. So at this time, the defense would call Melanie Tenaglia.
Do you solemnly swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
Ms. Conlon?
Please tell us your name.
Melanie Tenaglia,
And what is your relationship to Danielle Redlick?
sister.
Is she your oldest or,
She's the oldest, yes. She's
okay.
2 years
And
older.
how many total siblings are there?
There's me and her, and then my mom had 3 more. So there's 3 half siblings on my mom's side and 3 half siblings on our father's side. So 3, and then the 2 of us.
Did you grow up, where did you grow up?
With my mom. So there would have been 5 of us together grew up.
Did you live in Cleveland, Ohio?
Yes,
At that time, did Danielle Redlick live there as well?
yes,
At some point, did Danielle Redlick move to Memphis?
yes,
And did you also move to Memphis?
yes.
Where was Michael living?
With
By Michael, I mean Michael Redlick.
in Memphis.
Did you know Michael Redlick?
Yes.
And what was his relationship to Danielle? As in, like, were they husband and wife?
At that time,
Yes, in Memphis.
yes, husband and wife.
Right. When you moved to Memphis, did you spend time at the Redlick home?
Yes.
How often would you see Danielle during that time?
A couple times a week.
And did you ever see any physical acts of violence during that time in Memphis?
I saw one, yes.
Okay, can you describe that?
My kids were spending the night at their house and they were ready to come home. So I went to go pick my children up and I walked in the front door as I would always, and I was saying, dance, dance. And I walked straight back to where when you come in the front door, if you walk straight back, her room was back there looking for her. And when I turned the corner, I heard Michael calling her a bitch. And when I looked over, she was in the back of her closet.
When you say she, who's she?
I'm sorry, Danielle was in the back of their walk-in closet with her back up against the wall, and Michael was in her face, towering over her to where she couldn't like get around him.
Was Michael yelling at her?
Yes.
Did it look like an aggressive situation?
Yes.
And what made it look aggressive to you?
It didn't look like she could get out, and he was like screaming at her I heard him saying, bitch, you're a bitch. And I turned around and walked out and said, let's go to my kids. And then I left.
Over Danielle Redlick while they were in the closet.
Yes.
And was Danielle's back to the closet wall?
Yes.
And so Michael was in front of Danielle?
Yes.
And was there lots of room from Michael's back?
To me? To the opening of the closet?
Yes.
Yeah.
No further questions.
And then, Your Honor, just for the record, if I can cross her.
Okay.
Thank you, Judge. Good afternoon.
Hi.
Hi. So let's talk about this incident that you were describing on direct examination. So you walk into the house and you hear yelling, correct? Into Danielle's house, right?
Yes.
Okay. So you go back to where the yelling is, true?
No. When I walked in the front door, I didn't originally hear yelling.
Okay.
I walked in the front door and I didn't see anybody because you could see the living room, kitchen, dining room area. And I said, dance, dance. Cause that's how we would just go in and then I'd look for her and say, I'm here for the kids or whatever. As I walked closer to the bedroom, which would be straight back, I heard him yelling.
Okay. So when you originally walked in the door, you couldn't hear any yelling, correct?
Correct.
Okay. So it was only when you got back closer to the bedroom door, that's when you heard the yelling, right?
Yeah. Yes.
Okay. And then when you actually saw, so you looked into the closet, right? Correct?
Yes.
Okay. And it was the master bedroom closet, right?
Right.
So it was a walk-in closet.
Yes.
Okay. And when you looked into the closet, you saw Danielle with her back against the wall, right?
Right.
And you said that Michael was over top of her, right?
Right.
Okay, but you never saw Michael touching her, correct?
No.
And you didn't see Michael hit her, right?
No.
You just heard Michael yelling, right?
Right.
And then you said something, right? Like, let's go or something like that to the kids?
Yeah.
Okay. But before you left, you actually saw Danielle and Michael exit the closet, right?
I didn't see them come out of the closet. No.
You didn't see them come out of the closet?
No.
Are you okay?
I was in the kitchen. They were in the room. So if they would have came out of the closet, I wouldn't have saw them exit the closet.
But they came out, but you did see them once they came out of the closet, right?
I saw Michael.
You never saw Danielle?
No.
And do you remember giving so your testimony here today is that you only saw Michael out of the closet, not both of them, correct?
Right.
And do you remember giving a deposition in this case?
Yes.
And it was on May 29th, 2020?
Yes.
And Mr. Wiggins was present at the deposition?
Yes.
And a defense attorney was present at the deposition? Commissioner Pro, Your Honor? Yes. I'm going to reference page 24, line 16 and 17. Actually, 15 through 17. And I'd like you to read out silently as I read aloud, starting on line 15. I turned around and walked out and said, Kaylee and Sam, let's go. He must have heard that I was there, and then they came out. Did I read that correctly?
Correct.
Okay, so they came out, correct?
Correct.
So both Danielle and Michael came out.
Well, I assumed Danielle came out because he came out, but I only saw Michael.
But in your deposition, you said they came out, right?
Right.
And that evening after you left, you never called the police, right?
No.
That evening, you never saw Michael touch Danielle, correct?
No.
So is that a yes? So Michael did not hit Danielle, correct?
No, not that I saw.
Okay. And you never saw him touch her at all. Is that true?
Correct.
Objection asked and answered.
And when you then you left that evening, correct? With your kids?
Correct.
And you left Danielle there, correct?
Correct.
She didn't come with you, right?
No.
Nothing further, Your Honor.
Can you redirect?
No, Your Honor.
Okay, thank you, ma'am. You may step down.
On record? Yes. Okay, so I would cite to Smith v. State, 606 Southern 2nd, 641, Florida 1st DCA case 1992. The court there held that when self-defense is raised, evidence of prior specific acts of violence by the victim is admissible to reveal the reasonableness of the defendant's apprehension at the time of the incident. The standard is that before a defendant may offer this type of evidence here, she must display a proper predicate demonstrating some overt act by the victim, which may be reasonably regarded as placing the defendant in imminent danger. All doubts as to the admission of self-defense evidence must be resolved in favor of the accused. An overt act on the night of the incident, and therefore that prior incident goes to the reasonableness of the defendant's apprehension. In Farrell v. State, 273 Southern 3rd 43, Florida 4th DCA 2019. In this case held that third-party testimony was allowed to corroborate defendant's testimony. And in this case, the defendant has stated that she was manhandled in Memphis, and this is corroboration of that.
What case was that again? That was Farrow v. State?
Yes, it is Farrell v. State, 273 Southern 3rd 43, Florida 4th DCA 2019.
Next one we would do is the video exhibit. So when we come back, I will enter the text messages, the color version, without objection, and then this, but I want to make sure it works. I think we're still logged into where we had Dr. Azar testifying. Are we able to not be?
Should work now.
Okay, so I should be good on that there.
Did you,
Yes,
are you ready?
Jury, we will enter the two texts, and then we will enter the video, and then we will play the video testimony of Mr. Yutzi. And then after that, the defense would rest.
Okay. So let's bring in the jury. From your lunch, Mr. Parnell, your next witness or your next presentation of evidence?
Judge, at this time, the defense would move to enter defense identification Q into evidence as a color version of the text entered yesterday as Exhibit 7.
And is there any objection from the state?
No, Your Honor.
So defense Q will be admitted as the next numbered exhibit.
Defense Exhibit 11.
The defense would seek to move for identification defense R into evidence as a color copy of the text messages entered yesterday as Defense Exhibit 8.
Any objection?
No, Your Honor.
Defense R is admitted as the next numbered exhibit.
Defense Exhibit 12.
Next, we would move to enter defense for identification K into evidence as the prior videotaped testimony of witness Yutzi.
Any objection?
No, Your Honor.
Defense K is the next numbered exhibit.
Defense Exhibit 13.
Permission to publish diagram.
Yes.
Testimony you're about to give shall be the truth, the whole truth, and nothing but the truth.
Yes.
Please be seated, sir.
I'm sorry.
Yes, please. State your full name, spell your first and last name.
Ted Yutzi, T-E-D-U-T-S-E-Y.
Mr. Parnell,
May the court inquire if the jurors are able to hear the testimony?
can you all hear? Nodding yes? Okay.
I have a couple of no's.
Couple no's? Okay.
Possible for the court to raise the volume on that?
I just did, so let's see what happens now.
Mr. Hughes, you said you're aware we do have a camera recording you right here to be played for the jury, okay?
Does that matter?
Mr. Hughes, what do you do for a living?
I'm a handyman.
Can you make sure you stick up so the microphone can catch you?
I'm a handyman.
How long have you been doing that?
About 6-7 years now.
In Orlando?
Orlando and the Springs, all over.
Have you ever had occasion to meet Danielle Redlick?
Yes.
How about her husband, Michael?
Yes.
How long have you known the Redlicks?
Before I started working for them, or about
You know them before you started working for them?
just seeing the same height, but not physical until I started working for them.
Okay. Where did you encounter them before you worked for them?
Like I was working with the neighbors, and they needed help, and that's when I first met them.
So you just saw them across the street?
Yes.
Have you ever interacted with the Redlicks outside of work environment?
No, not really.
And did you ever work with the Redlicks?
Yes.
Approximately what time was that? Like what year, day, month, if you know, to the best of your recollection?
I think it was like 2018, 2019. I'm not sure. Yeah.
And where was the location where you performed work?
At the house. On Temple Drive.
In Winter Park?
Yes.
What work did you perform for the Redlicks?
I fixed up a bunch of things in the household. They were going to get ready to sell or stay, but they wanted to fix it up.
Okay. Did you ever fix the front door of the home?
Yes.
Can I have this witness to show defense aid for identification?
Yes.
Do you recognize this?
Yes.
Okay, and this photograph, can you tell the court what that is?
That's the front door of the Reddick's house.
At the home where you repaired it?
Yes.
Okay. Your Honor, is this a true and accurate reflection of what the door looked like when you did the repairs?
Yes.
Your Honor, this time I attempt to move defense exhibit A to evidence defense 1.
Any objection?
No, Your Honor.
Defense A is admitted as defense number 1.
Have been published to the camera. I'm sure if we can see this, but fine. How many times did you repair that door?
Excuse me?
How many times did you repair that door?
Twice.
Do you remember when those were? First and then second?
I can't tell exactly the time, I'll be honest. But I know the first time the door was broken where it wouldn't lock, it wouldn't close, and the hinges was damaged.
Okay.
The lock hinges on the side.
Were both of these times in 2018?
Yes, back to back.
So the damage on the door the first time that it was, where was the location on the door of the damage? So where had it been broken?
How can I explain that? Because when the door closed, there's one door, since it's French doors, one door says lock. So there's a locking element on top and bottom to lock one side. Well, those were broken. Like it was broken. It wouldn't stay closed. So what I had to do is I had to take out, I call it the brings, and reinforce them to make them lock and put new wood on front. I put a thicker wood so it could close right and it seals the door from getting the air in and from the other door slamming in and out.
You said a thicker wood. Is that a thicker wood than had previously been on there?
Yeah, because what happens is when the door was, the way they had it is the door wasn't aligned right. So I had to take a piece of, I want to say 3 inch by 3/4 inch wood and put it up to stop the door and seal it so the air won't go in.
So is the door made stronger than it was before it got broken?
Yes.
Do you know how the door got broken?
I don't know.
Let me ask you this way. Were you present when the door was broken?
The first time, no. I didn't know how.
And without telling me what anybody said, if the answer is yes, Did anybody ever tell you how the door got broken?
No.
Based on what you observed, were you, with the damage to the door, were you able to tell how it was broken?
The first time, no. The second time, yes.
Okay. So the second time, do you recall the date for that or the rough guess on the date for that?
I can't tell. I know Mr. Reddick called me and told me to come over because he wanted that door fixed.
Okay. And this would have been 2018 as well?
Yes.
The second time, what did you observe as the damage to the door?
The second time what happens is the brains and elements was, the door was kicked in. The wood that I put up was broken. It was cracked. And the elements, I had to replace them totally this time. So that was on the door that was, on the first door, it was on the other side of the door that was broken also. So it had to be kicked in because you can't do it from the inside. It had to be
So
from the outside.
the door would have had to have occurred from something hitting it from the outside?
Yes.
Outside meaning towards the street as opposed to inside the home?
Yes.
Did the doors open into the home or outside?
Into the home.
They opened into the home? Did anybody tell you how the doors were open that second time?
No.
So what you said is based on what you observed yourself?
Yes, because I told him what happens is when Reddick called me over, I said this is not due to anything I did.
You're set. Hold on. Mr. Parnell? Hold on just a second.
I'm not seeking the substance of anything
Okay,
that
hold on
was
just
said.
a minute. I was just trying to find it where I was. I don't think so. I don't think that's hearsay. Objections overruled.
Not responsive. You said council knowledge, it was responsive.
Mr. Cornell, I don't think it is. It looks like you're talking about what the witness observed, and I don't think that's what he's answering.
Right,
So can you ask your question again? I'll sustain the objection on being non-responsive.
Okay, so I think I had previously asked, did anybody tell you what happened to the door? And you had said no, correct?
No. Yes.
So the damage that you described as seeing, that's your opinion from what you observed yourself. Is that fair?
Yes.
When was the last time that you were in the Redlick home prior to Mr. Redlick's death? Are you aware that Mr. Redlick has passed away?
Yes.
Do you know when that was?
It was in, I think in January or February. I'm not
Were
sure.
you aware of it close to the time when it happened?
What do you mean? I'm sorry.
Were you made aware of his death soon after it happened?
Yes.
So prior to him dying, how long before that was the last time you were inside the home?
In December sometime.
And that would be December 2018?
Something like that.
Did you ever have an opportunity to go inside the master bathroom of the home?
Yes.
Was that during the December 2018 visit?
I don't recall that one. I'm sorry.
Do you recall when the last time you would have been inside the master bathroom of the home would have been?
When I was changing the locks, I think. I don't know, for the doors.
The locks to, was this the main door or to?
I changed all the doors in the house. All the locks in the house.
Okay. The last time you were inside the bathroom, was there any damage to the door entering the master bathroom?
No.
Can I approach the witness with the kid's identification bead?
Yes, you named it.
Ms. Sheetsy, do you recognize what these photographs depict? You can look this at them if you want.
Yes.
What do those depict?
That's her bathroom.
The bathroom that we were just speaking about?
Yes.
And the condition of the doors, is that a condition that you ever observed those doors to be in?
No. I fixed, no,
Is that damage that you ever fixed yourself?
not that, no.
And had that ever been done prior to the December 2018 visit that you made to the bathroom?
No, this wasn't like this.
At this time, I would seek to enter defense B as defense 2.
Any objection?
Yes, Your Honor. Predicate has not been laid.
Is there one question that you want to ask him about the pictures?
Is that an accurate reflection of the bathroom as it stood when you visited the bathroom of the home? I'm asking about the bathroom itself, not the door specifically.
I'm lost, I'm sorry.
Would you like to see the photograph again?
Yes.
Okay. You said you recognize what the photographs depict?
Yes. When
Do the photographs depict the bathroom, the master bathroom of the Redlick home?
yes, this is his master bedroom, and I put those locks on. The door wasn't like that.
So my question to you is, do the photographs that you have in your hand accurately depict the bathroom as you know it?
Yes.
Judges, be wrong as a defense attorney.
Any objection?
Yeah, Your Honor, can we just approach?
I'm sorry.
Mr. Easy, may I first witness again? For the file numbers on the bottom of these photographs, can you tell me for the photograph of the door, the two file numbers that you see on the bottom of the photograph for 1 and then 2?
3244.
So the first one is photograph file 3244,
Yes.
and the second?
Second one is 3375.
3375. Thank you. Mr. Easy, did you ever see physically yourself observe the Redlicks fighting physically?
No.
Did you ever see them yelling at each other, screaming? Don't tell me anything that was said, but just did you ever see that?
No.
I don't have any further questions.
Thank you. Mr. Wiggins?
Mr. Bootsy, the last time you had a reason to be inside the master bathroom related to when you were changing the locks,
Yes.
when was that?
Last time I was in the house was when they were selling the house.
Well, no, not the last time you were in the house.
Okay.
Because you're talking about after Mr. Redlick's death.
Yes.
You said the last time you were in the master bathroom was when you were changing the locks.
Yes.
Is that when they were selling it?
No.
Okay, so that would have been time earlier when Mr. Redlick was alive.
I'm sorry. I went ahead. After Reddick was past that, after he was gone, I've been in the house.
Oh, so you saw the bathroom. When you said the last time I was in the bathroom, it was, you're referring to a time after Mr. Redlick had died.
Yes.
And the bathroom didn't look like that after he died.
No.
You don't have any recollection of what the bathroom looked like before he died.
Before he died, it was when I fixed the door. It was intact.
Okay.
Because I put the locks on.
Yeah, but we're talking about that's the front door.
I'm talking about the bathroom door. All the black hinges is my work.
So you fixed the master bathroom door
Yes.
at some point.
Yes.
When was that?
Sometime October. Between I want to September, December.
Okay. Well, December was the last time you were there, right?
Yes.
And that was to fix the AC.
Yes.
So you didn't go in the master bathroom when you fixed the AC, correct?
No.
So would it have been closer to September than December?
September, October, November, December, September, October. It was between September and November.
Okay. So September or November
Yes.
is when the last time you were in the bathroom.
Yes.
The last time you could speak to the condition of the bathroom.
Yes.
You mentioned that the front door had damage to it.
Yes.
You refer to this damage as being, it looked like it had been kicked in.
Yes.
When you say that it looked like it had been kicked in, are you saying I saw footprints on the door frame?
No. I didn't see footprints.
You're just saying that there had to have been a force that was coming from the outside pushing in.
Yes.
Could have been a shoulder.
No.
Okay.
No.
Why not?
Because what happens is their lock is low, and what happens is the whole bottom lock and all of that I had to replace.
Okay, so you're saying it was damage to the lock area.
The whole frame. Yes.
You believe the most plausible explanation for damage to the lock area is someone kicking it?
Yes, because also I had to replace the brains on the bottom, and everything was bent, like it was forced that way.
You have no idea who's responsible for that?
No, sir.
You have no idea who's responsible for any of the damage that you observed in the house?
No.
I have no further questions.
Thank you. Mr. Cornell?
This is what, Mr. Easy, when you repaired the bathroom door that Mr. Wiggins just asked about, was that just doing the locks?
Yes, that's all I had to replace on this deluxe.
And that's the dates he had said between September and November.
Yes.
No further questions, Your Honor.
Okay, may the witness be excused and the subpoena?
Yes.
Yes, sir.
Thank you.
Mr. Parnell, your next witness.
Judge, at this time, the defense is rest.
Ladies and gentlemen, I need to take up an issue with the parties, so the deputy will escort you to the jury room. Mr. Parnell, Ms. Conlon?
Yes. At this time, the defense moves for a judgment of acquittal. As for the second-degree murder charge, even in the light most favorable to the state has the burden.
We're not done with the trial.
Oh,
You have your rebuttal?
No, but we're just going to rebut their case, and then that would be the end of the trial, and then they would make JOA.
So you have a witness, you,
No, but we're going to do that tomorrow morning. So I'm just saying the case isn't over. They're making their
All right,
final
no,
JOA.
no, I do. I get it. So what you want to do now is recess for the day and then go through the jury instructions?
Yeah, I just don't think, I think State's can correct me if I'm wrong, I think it's premature when State's going to present a rebuttal case to do their final JOA.
It is.
Yeah, so then I thought we
We'll
would,
just wait. So we'll just do the jury instructions now.
that was the
I received my copy. Did you get yours, Mr. Parnell?
I did, Judge. We haven't gone through it yet, but we can obviously do that together while we're here. And I think we can excuse the jury for the day, as the court said.
Okay. Let's bring them back in, please. Let's see. I brought you all back in to tell you that we're done for the day. I have some issues that I can take up with the attorneys now that will make tomorrow a lot more smoother. So you're excused for today. Same admonition as before. Don't watch the news about this case. Don't research. Don't go to the places involved. Don't talk to anyone or let anyone talk with you about the case. Any questions about that? Probably not now after day 7, 8. Okay. All right. Have a wonderful evening. Stay safe. Oh, and then tomorrow. What time? Tomorrow, 9 o'clock. 9 o'clock. I can get through it. Can you print that for me? Instructions. Should reflect that counsel for the state are present and Ms. Redlick is present with her attorneys as we start the charge conference.
you want me to say?
Mm-hmm. Let's take a look at the jury instructions, the proposed instructions. Defense, any objection to introduction to final instructions?
No objection.
State?
No objection, Your Honor. Your Honor, may we address you while seated for this portion?
Yes, please. Statement of the charge. Should be charges, I guess. Any objection, defense?
Just as the court said, at the S.
State?
No objection, Your Honor.
Let me see. All right. Introduction to homicide. Any objection from the state?
No, Your Honor.
Defense?
This is acceptable.
All right, then the instruction on justifiable homicide. Is that acceptable, defense?
Correct.
State?
Yes, Your Honor.
Excusable homicide. Is this acceptable to the state?
Yes, Your Honor.
Defense?
Yes, acceptable.
Defense, count one, murder, second degree. Is that acceptable?
I'm going through it now for the first time. It appears to be standard instruction with no changes. Is that correct, Mr. Wiggins?
That is not correct. I've added the definition of serious bodily injury to
I see that here.
the instruction. And that definition is a definition that I pulled from the definition of serious bodily injury in DUI, serious bodily injury. So it's from another approved jury instruction.
I'm fine with the phrasing.
See what I'm saying?
Meaning they haven't seen the phrase serious bodily injury yet, so I think it should be defined after they've seen it, which is in that enumerated 1, 2, 3 that begins on page 3.
Yes, that makes sense.
Okay, I see what you're talking about. You're talking about the definition on page number 2 needs to come out. The one for serious bodily injury needs to come out, and then keep the one on paragraph. It's on the first paragraph after the 3 elements on page 3, correct?
Oh, I didn't get to the second one. Yes, it's the same thing as on there twice. Then yes, I would ask for the first one to be removed and keep the second one.
Okay. All right, so the, that particular section on page 3, any objection to that? Paying attention to the highlighted part that begins in issue in this case is whether.
I'm assuming the highlighted portion is the state saying they don't think that should be in there.
I don't know.
I just
Mr. Wiggins?
highlighted it because I didn't think it would apply, but I didn't want to make that decision without flagging it for the parties.
I don't think it applies. We're not arguing that. I'm okay with it coming out.
So that paragraph is going to come out, that highlighted paragraph. Right, I think I ended with defense. Let's see, defense, any objection, or is the next section acceptable? Aggravation of second degree murder by carrying, displaying, using, threatening to use, or attempting to use a weapon.
It appears to be standard, correct, Mr. Wiggins?
It is standard, yes.
Is That's acceptable?
Yes, acceptable.
State?
Acceptable, Your Honor.
All right, state count 2, tampering with physical evidence. Is that acceptable to you?
Yes, Your Honor.
Defense?
Your Honor, I don't know if the court confirmed that count 1 is acceptable to the state or defense in its sort of final form.
Which one?
Count 1, you just have it on the record. We made some edits, but we didn't confirm that it was acceptable.
Okay, then let me go back. Defense on count 1, murder, second degree, with those changes that were made, which are removing the serious bodily injury paragraph on page 2 and the highlighted portion on page 3. Is that instruction acceptable? State?
Yes, Your Honor.
Okay, so now going to the aggravation, we've already taken care of that one. Count 2, tampering with physical evidence. Is that one acceptable defense?
The word "or" maybe after the comma on the first paragraph. Redlick knew that a criminal trial or proceeding, comma, an investigation by a duly constituted law enforcement agency was about to be instituted.
So that a criminal trial or proceeding or an investigation that,
I think that would make it grammatically correct.
State?
Checking the standard. Redlick altered, destroyed, concealed, or removed any record, document, or thing. I'm sorry, I guess
no, I'm on, I think it's paragraph number 1 that you're talking about, right, Mr. Parnell?
Right, Judge. The comma in that first sentence, or in that first line for enumerated number 1. I just think the word "or" to make it grammatically correct before the word "and."
or an investigation, or yeah.
Or will be included there. And with that change, adding in the word "or" between proceeding and the word "and," there also needs to be a period at the end of paragraph 2. Is that acceptable to the defense?
I think for paragraph 2, we should put Danielle Justine Redlick to be consistent with the rest, not just Danielle.
I agree.
Okay.
So with those 3 changes, is that acceptable now?
Right, with those changes, acceptable.
State?
Yes, Your Honor.
Okay, so state when there are lesser included crimes, you have the lesser included crime of manslaughter. Is that acceptable?
Yes, Your Honor.
Defense?
Yes, that all appears to be standard and unchanged.
Okay, defense, manslaughter.
Acceptable. I think the highlighted part and the "or" that are present can be excluded.
State?
I agree.
Okay, so we will remove the highlighted portion in the numbered paragraph 2. And so I will remove the highlighted portion talking about the culpable negligence on page 4 and 5. Defense, is that acceptable?
Yes.
State?
Yes, Your Honor.
Okay, so state aggravation of manslaughter by carrying, displaying, using, threatening to use, attempting to use a weapon. One thing I see is in the 3rd paragraph, her middle name is missing. Consistency purposes, we'll
Yes, Your Honor.
use that. Anything else? State, with that addition, is that acceptable?
It is, Your Honor.
Defense?
Yes.
All right. The next one, defense, justifiable use of deadly force.
On this one, Your Honor?
Yes.
So for the applicable felonies section, we would be asking for the additions of manslaughter. Seven, 7, 6. Oh, wait. Yeah. 776.08 forcible felony.
Looking at the list that's on there, I trust you. I didn't think that was
So manslaughter, a few things that have no application, aggravated assault, aggravated battery, and then I think everything else is, again, no application here. And then the last at the end.
So you want, where it says applicable felony, you want murder, manslaughter?
Murder's already there in the front part of that sentence, so
Okay,
we
so
don't
you
need.
want manslaughter, ag assault, ag battery?
There's
not.
a quantum of evidence to justify aggravated assault or aggravated battery.
There, Mr.
Murder, the manslaughter, the aggravated assault, and the aggravated battery.
State?
There has to be evidence to support the giving of those felonies. And so let's just start with aggravated assault. There is, Ms. Redlick testified in no way, shape, or form that Mr. Redlick was armed with any sort of weapon, that she believed he was going to become armed with any sort of weapon. So I would say that the court needs to ask the defense to point to quantum of evidence that would even support that theory, which I don't believe exists within this case. And then aggravated battery, there's no evidence of an aggravated battery that occurred. There's no evidence of great bodily harm. That doesn't exist within this case either.
Okay, Mr. Parnell, with the aggravated battery, there isn't any great bodily harm,
Judges,
or I guess that's, well, there's no permanent disfigurement. We would
what
agree
we're
with that.
looking at is to resist another's attempt to murder her or any attempt to commit these offenses. So our defense is that because of her actions, there was not the result that the state is saying is absent. So we wouldn't anticipate that the actual great bodily harm from an aggravated battery that she has resisted would be present in this circumstance. So her fear and her reaction to an attempted aggravated battery is what the instruction is contemplating.
I will concede that I think that there is a plausible theory for aggravated battery. I'm not going to fight that, but there is no theory of aggravated assault.
Pulling up the
What
aggravated
do you
assault.
have?
I'm sorry, Judge.
Oh, no, I interrupted you. What did you have for aggravated? Do you have that would support that forcible felony? Because when I look at the jury instruction for aggravated assault, and if the second prong of section 4 of the fourth element applies, the
And that's
assault
what I
is
was-
made with a fully formed conscious intent to commit some felony upon Ms. Redlick. So what facts do you have, Mr. Parnell, that would support the aggravated assault?
I think her testimony in regards to the attack shows what the court was just looking at is that second prong of number 4. The assault was made with a fully formed conscious intent to commit felony charge upon victim, which in this case, as we just said, aggravated battery would be a felony that we're anticipating, along with the murder or the attempted murder that we were contemplating through her testimony.
The assault was made with. I'm comfortable with aggravated battery and the manslaughter going in that slot, not so much the aggravated assault. I'm trying to remember the facts that would support a fully formed conscious intent to commit the aggravated battery. Okay, so the paragraph will read, the use of deadly force is justifiable. If Danielle Justine Redlick reasonably believed that the force was necessary to prevent imminent death or great bodily harm to herself while resisting another's attempt to murder her or attempt to commit ag assault, aggravated battery, or manslaughter upon her for any attempt to commit those applicable felonies upon or in a dwelling house in which she was present.
Defense requesting the dwelling house language?
I don't know. Are you requesting the dwelling house language, Mr. Parnell?
She's in the house, so yes.
So that would stay in. So let's just look at page number 5 with what we have here. Is that part acceptable to the defense?
As we just discussed it with the changes contemplated, yes.
For the state?
Yes, Your Honor.
Let's go to page 6. And then it says to give the elements of the applicable felony that the defendant alleges the victim attempted to commit. And so those 3 instructions for ag assault, agabet, and manslaughter will be inserted at the top of page number 6.
So that's going to take some tweaking.
To say the least.
Your Honor, if I may suggest, the manslaughter instruction has already been previously given.
So just state on there that it's.
Yes, Your Honor, and we only have to define the ag assault and the ag bat.
I agree with that.
I agree with that too. Okay, so we'll include the ag assault and ag bat at the top of page number 6. The next paragraph would read, Danielle Justine Redlick was justified in using or threatening to use deadly force if she reasonably believed that such force was necessary to prevent imminent death or great bodily harm to herself, or the imminent commission of, and then those 3 felonies against herself. If Danielle Justine Redlick was not otherwise engaged in criminal activity and was in a place she had a right to be, then she had no duty to retreat and had the right to stand her ground. Are you asking for that paragraph, Mr. Parnell?
Yes, I think we can take the or threatening to use deadly force out.
Okay. As to that particular paragraph, is that acceptable to the defense?
Yes, the way the court read it, and then just taking out the or threatening to use deadly force, since that's not what she's accused of here.
State?
Yes, Your Honor.
To do the exact same thing we had previously done. Those 3, listed 3 offenses have already been defined for you.
Agreed, no need to do it again.
State?
Yes, Your Honor. That's acceptable.
Defense. This is talking about the stand your ground. In a dwelling or residence. But she's not really defending a residence, though. So, yes, she's in the house, but someone's trying to, your classic example would be as if someone's trying to break into the house, maybe. Let me think. Do you want this next paragraph, Mr. Parnell? If the defendant was in a dwelling in which she had a right to be, she had no duty to retreat. Do you want that?
We certainly want that in there. What I'm just looking at is whether that is repetitive of the paragraph above it. It's not quite.
It should. Well,
it's similar, but not quite. So yes, then I would be asking for that language.
State?
Yes, Your Honor, I think they get it. It just, what they don't get is the presumption of fear portion of the instruction.
So it will read, if Danielle Justine Redlick was in a dwelling, or do you want it to say residence?
Residence, I think, would be more appropriate.
If Danielle Justine Redlick was in a residence in which she had a right to be, she had no duty to retreat and had the right to stand her ground and use force, including deadly force, if she reasonably believed that such conduct was necessary to prevent imminent death or great bodily harm to herself, or the imminent commission of the 3 felonies we've talked about against herself.
Correct.
Is that acceptable?
Yes, Your Honor.
The elements of those offenses have already been explained to you.
Agreed.
Mr. Wiggins?
Acceptable, Your Honor.
And so I will read in all cases, in deciding whether Danielle Justine Redlick was justified in the use of deadly force, you must consider the circumstances by which she was surrounded at the time the force was used. That paragraph continues on to page 7. The last line, however, the defendant had no duty to retreat if she was not otherwise engaged in criminal activity and was in a place where she had a right to be or was in a dwelling or residence. I say she was in a residence in which she had a right to be.
So would that last part be, and was in a place where she had a right to be, or was in a residence where she had a right to be?
Yes. She
You'd
was
be
in a
clear if you
place.
just picked one or the other.
Right.
I think in a place where she had a right to be there is fine.
I think it should track the dwelling
Right.
because that's what they've seen previously.
Yeah, we saw residence up there earlier, right?
Or residence. I think it should track the residence.
Yeah, that's fine, since we, to be consistent, in a residence.
Okay, so it would, the last line, however, the defendant had no duty to retreat if she was not otherwise engaged in criminal activity and was in a dwelling, no, in a residence in which she had the right to be.
That's acceptable.
Or is that acceptable to the state?
Yes, Your Honor.
Presumption of fear would come out.
Agreed, out.
State.
Yes, Your Honor. Agreed.
The next paragraph says, however, the use of deadly force is not justified if you find Danielle Justine Redlick used force to initially provoke the use or threaten use of force against herself.
She says in paragraphs.
Unless, and then there's paragraphs 1 and 2. Applicable, but not paragraph 2. Right.
I was talking to counsel. What was that?
I know I could hear y'all. Y'all pushing the button?
We were pushing the button.
We're pushing the button, Judge.
Are you pushing it and holding it?
Yes, Judge.
Trying to.
Yes, and try. Those are 2 different things.
I failed before, so I don't want to. My finger slipped before.
Okay.
So we're going to read one or two, 1 and 2.
I was just going to read 1.
Yeah, I don't believe that we have evidence of 2.
Defense?
Agreed.
All right. So 2 is coming out. Next paragraph would be reputation of victim known by defendant. If you find the victim had a reputation of being a violent and dangerous person, and that his reputation was known to Danielle Justine Redlick, you may consider this fact in determining whether the actions of Danielle Justine Redlick were those of a reasonable person in dealing with an individual of that reputation.
We skip a few paragraphs, Your Honor? I'm sorry.
The 2 between the highlighted portions.
Yes.
I think those are applicable and acceptable.
State?
Yes, Your Honor, I believe they are both applicable and acceptable.
These are applicable and acceptable. Okay, so now back to reputation of a victim known by the defendant. I think that paragraph stays in. The other one,
I think both come out.
We did not have any testimony of reputation evidence.
There's no reputation evidence.
come out. And then the last paragraph is, in considering the issue of self-defense, you may take into account the relative physical abilities and capacities of Danielle Justine Redlick and Michael Redlick. Any objection to that paragraph, defense?
No objection to that paragraph.
Okay. Okay. And then there are two paragraphs at the top of page 8. If in your consideration of the issue of self-defense, you have a reasonable doubt on the question of whether Danielle Justine Redlick was justified in the use of, need a space there.
We'll do it, some won't, and I would ask for it if the court's willing to change it to must find her not guilty.
I do. So the last sentence, or so the first sentence of page number 8 will read, if in your consideration of the issue of self-defense, you have a reasonable doubt on the question of whether Danielle Justine Redlick was justified in the use of deadly force, you must find her not guilty. Any objection to that, defense?
No, Judge.
8.
No, Your Honor.
And then we'll read the second paragraph as it's written. Any objections, defense?
No objections as written.
State?
No, Your Honor.
All right, state, your instruction. A justifiable use of non-deadly force?
I think threatened can go, Your Honor.
Defense?
I agree, threatened can leave.
All right. So we have, let's start with the first 3 paragraphs. And the applicable forcible felony would be those 3 previously listed. Any objection to those first 3 paragraphs, state?
Murder, I'm sorry, we'll put in murder, manslaughter, aggravated battery, aggravated assault.
Where it says applicable forcible felony listed.
Or is it 3? I thought there were 4.
We have ag assault, ag battery.
And then manslaughter, but murder was previously.
Murder was previously listed, but it's not here, so there are 4.
Right.
This brings up something we haven't discussed, which is we're referring to murder. And that's a very broad crime, and we're being asked to include the elements at some point. So We're going to tell them they're going to refer back to a previous instruction for that guidance. Should it say, should we specify murder? Not generally murder, just so it's very clear to them.
Then which level are you talking about?
I guess I would defer to the defense.
Mr. Parnell, which level of murder would you be considering there?
I guess because we'll need to have a definition is what you're saying.
So, yeah, so
How are they
if
gonna
we
define
say
Right.
second degree murder, then we can refer back to the second degree murder instruction as the definition.
I'm okay with them.
So it'll be second degree murder, manslaughter, ag assault, ag battery, all of which have previously been explained to you. Okay. The next paragraph says, in deciding whether Justine Redlick was justified in the use of non-deadly force, you must consider the circumstances by which she was surrounded at the time the force was used. Any objection to that paragraph, State?
No, Your Honor.
Defense?
No objection.
Next paragraph begins, however, the use of non-deadly force is not justified if you find that Danielle Justine Redlick used force. You want to keep in, you want to take out or the threat of force.
We should take it out.
Right.
So if you find that Danielle Justine Redlick used force to initially provoke the use or threatened use of force against herself, we'll take out or threaten use. Unless, and then there's paragraph 1 or paragraph 2.
Paragraph 2 should come out.
I agree. You, defense?
Agreed, 2 out.
Okay, so 2 is out. Let's turn to page 8. So that first sentence and that first paragraph, page 9 we're on now. If you find that Danielle who because of threats or prior difficulties with Michael Redlick had reasonable grounds to believe she was in danger of, fix the spacing, use of unlawful force at the hands of Michael Redlick, you may consider this fact in determining whether the actions of Danielle, should be Justine Redlick, were those of a reasonable person. Any objection to 1 and 2 staying in, State? With that one change to include Ms. Redlick's middle name in that first paragraph?
I have no objection to that. If you find Danielle Justine Redlick because of threats or prior difficulties paragraph, that's what the court's asking?
Mm-hmm.
Yes, I have no objection. That change.
Defense, any objection?
No objection to those, just a little language at the bottom of the second one in the last sentence where it says for her to use, threaten to use, just take out the threaten. So for her to use non-deadly force.
Okay. State, any objection to the second paragraph and taking out threaten to use?
No, Your Honor.
Okay. We'll take out the reputation evidence paragraphs. The next 3 paragraphs, can you take a look at those and tell me if those are acceptable, State?
They're acceptable, Your Honor.
Defense?
The only change would be the should to must, as we did in the last one.
Okay. And in the 3rd paragraph, shouldn't we take out or threaten use?
Yes, correct. So I guess that's in the second one as well.
Yes. So I'm going to change the second paragraph to you must find her not guilty and take out or threaten use in paragraphs 2 and 3. Is that acceptable, State?
Yes, Your Honor.
Defense?
Acceptable. This appears to be standard with no changes, correct, Mr. Wiggins?
Correct.
Then I think everything looks acceptable. I don't see any problems.
Except the last paragraph.
You have a reasonable doubt, you should find her. Yep. So we would ask for if you have a reasonable doubt, you must find the defendant not guilty as a change.
So with that changes that section, or is that instruction acceptable, defense?
Yes.
State?
Yes, Your Honor.
All right, weighing the evidence, state? Paragraph 6.
I don't think paragraph 6 applies, 7 applies, and I think 8 does apply. I'm sorry, I got ahead of the court.
No, you're fine. 6 is out.
Agreed, 6 out, 7 out.
7 is out. 8 stays in.
No.
Yeah.
Oh, sorry, I was looking at 9. 8
Oh.
stays in, 9, I don't think there's any evidence of that.
No evidence of 9.
Or 10.
Agreed, 10
No
also
10.
out. So 8 would be the only one and be renumbered to.
That would be the new number 6. All right, so removing 6, 7, 9, and 10. And renumbering 8 to number 6, is that acceptable, state?
Yes, Your Honor.
Defense?
Yes, miss.
Okay, so the next 4 paragraphs.
So is it going to read, I'm sorry, that's now what is now number 6. Did the witness at some time make a statement that is inconsistent with the testimony he or she gave, or just she?
I was gonna say they.
He or she would be, I think, the best way.
He or she? Okay. So that's number 6, yes. The next 3 paragraphs state, are those acceptable?
Yes, Your Honor.
Defense?
The next 3, yes, and then child witness.
No child witness.
That would only depend. If one testifies.
A young witness, but not a child witness.
Right, I'm not asking for that to be in.
Oh, okay. So we'll take out that one. And then the last 3 paragraphs, are those acceptable, state?
Yes, Your Honor.
Defense?
Yes, looks good.
Okay, so defense, your turn now on defendant statements. Is that acceptable?
Yes.
State?
Yes, Your Honor.
All right, state rules for deliberation.
No questions. 7 can come out.
7 comes out and 8 is renumbered to number 7. So that's acceptable with that change, state?
Yes, Your Honor.
Defense?
Agreed, 7 out, 8 is correct, so yes, agreed.
Okay. Defense, cautionary instruction, is that acceptable?
Acceptable.
State?
Yes, Your Honor.
All right, state, single defendant, multiple counts. Is that acceptable?
Yes, Your Honor.
Defense?
Acceptable.
Defense verdict. Is that acceptable?
Yes, it appears to be acceptable.
State, is that acceptable?
I'm sorry,
We're on verdict.
I started pulling up the verdict forms, got ahead of myself. Yes, Your Honor, that's acceptable.
State, submitting the case to the jury.
It's acceptable, Your Honor. I could give the court the exhibits that aren't going to go back.
Which ones are they?
That would be exhibit 28. Once I assume that deputies don't want knives going back there. So exhibit 28, 1 silver knife with black handle. Exhibit 29, 1 knife with black handle. Exhibit 30, one knife with white handle. Exhibit 31, silver knife, wood handle.
I'm just going to list 28, 29, 30, and 31. Just those 4.
Will the court just put like the knives so they know what we're referring to?
In parentheses, I'll go 28 through 31, parentheses, knives.
That's acceptable to see.
Mr. Parnell?
I think the testimony
does not go back.
Agreed for UC and the doctor, Vanderbilt.
It does not.
Right, agreed. Stays in the courtroom if they need to hear it.
What numbers were they? And that would have been state, would that state's 1?
17.
Oh, 17? And state 17 would be the ER doctor? Question mark.
Right.
Yes, that's correct.
Add in 2.7 right before rules for deliberation. That's the closing argument one. Closings, I will come back with the final instructions, beginning with rules for deliberation on down. So we'll need to add in 2.7, which is closing arguments. With that change, is submitting the case to the jury acceptable to the state?
Yes, Your Honor.
Defense?
Yes, that's acceptable.
Your Honor, Mr. Parnell also, sorry to jump around, but also raised that maybe we should not send the laptops back.
Or the phones.
Okay, so what numbers are those exhibits?
If 14 is one laptop, 23 is the second laptop.
And 34 is the defendant's cell phone.
Yes, that should not go back just in case they can get on the internet or something crazy.
So I had that are not going back. (28, 29, 30, 31). So they're 8. Is that what you have? No, that's 9. 1, 2, 3, 4, 5, 6, 7, 8, 9. So 9 exhibits that are not going back. State defense, will the bloody towels and the t-shirt go back? Nope.
What about the T-shirt?
Is it fire or bio? Oh,
Okay.
so what exhibit was that? I know it was the big bag.
Towel is 25.
I think they should get it unless there's a policy that says they can't have. I mean, this is evidence. They can, for them to see. It's unrealistic to, I mean, let's say they care about the towels and the shape of the towels, to ask them to come out here and be manipulating towels they have a right to look at in front of us. So unless there's some true security concern or policy, we give them gloves and they get to look at the evidence. That's my position. I'm not trying to trump a security concern though. But I don't.
Is there a security issue? No. Okay, well then, they shall get the bloody towels and the shirt, and we'll just send back gloves in case they want to.
Some of them aren't opened, so if they want to open them, I'm not sure.
Can give them scissors. Or they can, yeah, if they want scissors, they can, they'll tell us, I think, if they want scissors, and we can give it to them.
Okay.
I doubt very seriously they're gonna start going into that nasty stuff. It's theirs too, if they want to.
All right, that'll be up to them to decide if they want to look at it. Will they have a blank laptop, one that doesn't have access to the internet for the CDs?
Yes, Your Honor, they will.
I can't see anything else that would be an issue.
And just so the court's aware, Ms. Garcia's been kind enough to start working on the other definitions so they can be inserted into the instructions. So she's almost done, and so that those can be provided.
And then you want me to make the other changes, like the S and, just the smaller changes, or is Ms. Garcia doing them all?
But she's just doing the aggravated assault, aggravated battery instructions, so the court can insert those into the. From my experience, Your Honor, you normally sort of take over from this point as far as fashioning the final instructions.
Yes, sir.
So I was kind of counting on you to make those changes and provide us the.
I will make those changes.
But we're trying to be helpful in putting that.
You are. You are.
I don't know if we want to discuss the verdict form.
Let's go on and do that. Verdict form is to count 1 and count 2. Count 1 has, we, the jury, find the defendant guilty of second-degree murders charged in the information. We, the jury, find the defendant guilty of the lesser included offense of manslaughter. We, the jury, find the defendant not guilty. Will the jury find the defendant commission of said offense? Display, use, threaten to use, or attempt to use a weapon? Or we, the jury, find the defendant during the commission of the offense personally did not carry, display, use, threaten to use, or attempt to use a weapon? Are we keeping in threaten? I guess we are, because that was what was charged in the information. Are we keeping in threaten?
Yes, Your Honor. I wanted that language. We should track the enhancement language precisely.
Okay. I would like to read, I think that should go right after count one.
Between 1 and 2.
Yeah.
I think that makes more sense.
Mhm.
Yes, I agree.
And I'm
Judge.
taking out the word she before the word personally. Said offense, she personally. I don't think she is necessary.
I think that's correct.
I'm sorry, Your Honor, I missed
On the special finding, where it says she personally, and then they're gonna check did or did not, I'm gonna take out she.
that. So just gonna read personally.
Yes. Defendant during the commission of said offense personally did
Okay,
carry.
yes, Your Honor. Yes, I see. It makes sense.
At the top where it says answer if you find the defendant, should we put answer only or only answer if? I don't think that that's confusing, but I've had verdicts where they find him not guilty, but also.
And then they check the box. Yes, I've seen that. I've also considered on count one, the verdict form, saying something to the effect of, if you found the defendant guilty, please answer the question on the special finding, or please refer to the special finding.
Your Honor, I think that the court, it's within the court's sort of ability in instructing the jury to say that while you're reading the verdict forms, is to read the verdict form and then just provide a little bit of guidance about if you were to, you would address this form.
I agree with that orally instead of
We'll do it orally, okay. All right. So with those changes on the special finding, defense, do you have any objection to the verdict forms?
No, the verdict forms are good.
Defense, state.
No objection, Your Honor.
Okay, so I will wait for Ms. Garcia's,
We just sent it, Your Honor.
and I literally just got it. Okay. So I will work with this and add
First-
that in where you,
There are just a few decisions that Mr. Parnell needs to make.
on ag assault.
Yes, Your Honor.
Mr. Parnell, do you have that up?
Really aggravated battery needs some input from Mr. Parnell.
I'm sorry, let me pull it up. I want the deadly weapon language for point 2 here.
Well, I assume that you guys just want A for element 1. And for 2, there's 3 options. I don't know if you want all 3. But I think we can agree that there's no evidence of deadly weapon.
I could want it all to be in except for, as Mr. Wiggins said, that D used a deadly weapon, and then a deadly weapon definition is not taken out. Or the one after that.
So aggravated battery, we'll have paragraph 1A. And also 1B.
Yes.
So it's 4 between A and B, and then paragraph 2. In Michael Redlick, in committing the battery, intentionally or knowingly caused great bodily harm to Danielle Justine Redlick, permanent disability, permanent disfigurement. I don't see permanent disability or disfigurement.
This is the part that, again, the evidence does not need to have, or the harm does not need to have happened. It's in regards to her fear and her justified use of force. So
Okay, so you want all 3 in?
I
That's
think
right.
all 3 with an or comma, or.
Co-counsel raises, I think, about a point. I don't know what the evidence of permanent disfigurement is. I can understand disability related to maybe
This part here, maybe. Oh, I'm talking great bodily harm. I was thinking maybe the fist and the face.
No, I'm
Permanent disability.
So maybe I don't want to make defenses. The one that I'm focused on that I think truly doesn't have a quantum of evidence is permanent disfigurement. There is nothing, no aspect of the conduct created that risk.
We have a definition of disfigurement. I don't see it in there. Trying to look at it.
There was not one in the instruction. I didn't put out any definitions.
Talks about scarring, I think, in the case law.
I can't see, even if I'm stretching it, I can't see permanent disfigurement. I don't necessarily see permanent disability either, but I think there's an argument that can be made for great bodily harm.
Yeah, I'd agree on disfigurement not really being appropriate here.
What about permanent disability? What's the argument for that, Mr. Parnell?
I think we're okay with just very bodily harm. United for so just the first of the 3.
Taking out the next 2 paragraphs dealing with deadly weapons.
Correct.
There will be the paragraph for great bodily harm. And I'm thinking maybe the last paragraph does come in, and intentional touching or striking includes situations where a defendant knows that a touch or strike is substantially certain to result from his or her act. I think that stays. State?
Yes, Your Honor, I think that stays.
Defense?
I'm fine with that staying.
Okay.
And then if we could just move to aggravated assault.
It's the same issue. No deadly weapon.
No deadly weapon. So just B. in element 4.
And then the felony charge will be second degree manslaughter, ag assault, ag battery.
Regarding, this is the charge for ag assault, so it can't be ag assault.
Nope, can't be that. You're right. So it'll just be second degree manslaughter and ag battery. So for aggravated assault, I would
Yes, Your Honor.
So tomorrow, which witnesses are we going to start with tomorrow morning at 9?
Detective Pamela Ware, Andy Jones, Jaden Redlick, and potentially one other witness that I haven't decided yet. I need to decide this evening.
Plus one more. Okay.
There's one other issue I'd like to raise, unless the court has other matters it wants to address.
I don't have any.
I think now is probably maybe an opportune time to address the issue related to our juror in the far left bottom seat, who there was some concerns about his whether he was sleeping during the sort of technical testimony portion. My observation of this juror since then is he has been very alert and engaged in the testimony. Haven't seen that pop back up. And so juror number in seat 42, I believe, for the record. So I just wanted to raise this. I think we talk about it now rather than after closings and we're figuring out who do we send back there. I realize that that's a question that maybe was left hanging. The state's position is, with his rapt attention since then, I think that he doesn't need to be stricken. And the other complicating or the other consideration the state has is that the next alternate also was drifting into maybe some apparent sleep for some moments on that same day. So we have two jurors that had sort of similar issues on the same day. We can't remove both of them. So I think that we keep him. There's not a reason to remove him.
I don't know who's taking that issue up for the defense. Ms. Conlon?
So the juror who was closest to the far left, I noticed today that his eyes were closed. It was closed for at least 3 or 4 seconds. By the time.
But like this?
Yes. Because every time, as soon as I try to get on the IM or to email the court or the state, because we had agreed that we would email each other, he opens his eyes. But there is a period of time where he keeps his eyes closed. And I'm concerned that given the fact that he had previously closed his eyes and it appeared that he had been sleeping, that he has not paid attention and has missed some critical information.
I didn't notice him sleeping today. I thought he was more alert today. I'm not saying you didn't see what you saw, Ms. Conlon. Please make sure you understand that. 3 or 4 seconds. I don't know.
I've been watching him a lot since this issue arose. And the day that he would seem to be maybe having some trouble with his attention. He was kind of like leaned against the wall. He was using the rail for support. Since then and today, he has been like, I've seen him, he's been leaning forward. He's been very engaged. And I think it's very difficult to tell the difference between sometimes sort of, looking down at your pad or maybe sort of dropping your eyes a little bit and sleeping. So I really, and I'm just, from what we've seen since then, since we haven't had any sort of inquiry with him that suggests that he, had any problems really paying attention and receiving the evidence, and the fact that our next juror had the same issue, we're kind of, I think that we don't have a clean solution.
Is that your front row? Is that the alternate?
The alternate is the older gentleman who sits in that chair he was in the tan jacket whenever he was having some trouble with attention. So if we were to remove the juror in seat 42, we'd be taking another juror that had the same issue on the same day. Yeah, and he was the same day, had the same.
Yeah. And we're talking about people kind of wandering on the technical, the DNA, the digital forensic.
Correct.
But all the other times, they've been attentive.
I've seen them every juror has been extremely attentive since the sort of the technical dry stuff has been over.
Juror in seat number 5.
Is that the third from the left?
That's the gentleman.
On the far left?
On the far left.
I don't know what the court saw, but I know the court saw it enough to make it matter. And I don't know that testimony on day 2 or day 1 is more important or less important than testimony on day 4 and 5. It seemed like we were all catching the same thing. And I don't want somebody that was dozing off and missing what seemed to be a pretty good bit of evidence, even though it was the state's case and they might have been paying more attention during the defense case. I don't think that sort of valuation is appropriate for this part.
I don't know of a clean solution for this one.
I think the clean solution would be to have the guy that keeps falling asleep be absented, and then alternate 1 become, I guess, switch spots with him. Well, he doesn't need to be an alternate either if he's.
But didn't you say alternate number 1 was dozing off too?
I think Mr. Wiggins had said that.
I did not. I will tell you, I didn't see alternate 1 dozing.
Right.
I did not see that one. So
Somebody
that would be
mentioned it last
something-
week, though. It's not coming up for the first time today. I agree with that. I don't remember who saw it or what they saw. So if your memory is better than mine on
Yeah.
that.
I thought so. I thought defense or the court pointed it out. I don't think I pointed it out to my recollection.
Was that us? Number 3 on the front row.
So I had noticed that the tan jacket person
Conlon
Ms.
pointed.
Conlon
Yeah.
pointed that out.
had also had that issue when we were brought up to address.
If we didn't have 2 that were having some focus issues during the technical stuff, you'd say, "Oh, just go to the next guy." But the next guy has the same issue, and we can't remove both of them because we wouldn't have enough jurors. So I just think, if defense is asking to remove him, I think that what the court would need to do is actually engage in a colloquy with him and determine on that day, we noticed that you had some alertness. Do you believe that your whatever problems you were having with alertness compromised your comprehension and appreciation of the evidence?
No, Your Honor. Mm-mm.
Well, if he says no, then we have to, in all aspects of this process, accept that their representations as jurors. They're under oath when they're speaking to the court. Or he could be a person who says, I have to concede I was, I worked that night. I shouldn't have worked. I came in sleepy, and yeah, I dozed, and there were portions of his testimony I know I didn't take in. And if he says that, he should be gone. But we shouldn't, if that request is the one that's coming, which is why I'm addressing it now, we need to be prepared for how we deal with it efficiently, so we're not delaying deliberations, doing what we're doing right now. So that would be my proposal if that's ultimately what the defense is going to ask when we go to charge this jury.
I don't think having a colloquy with him is going to actually get to anything, as the court said. I expect he's just going to say no regardless. And it might not be lying. It might be sometimes if I'm falling asleep watching a TV show, I don't realize I fell asleep. And then I don't understand what's going on because I've missed 10 minutes without understanding that I've missed 10 minutes. And I don't think it's choosing to lie or not choosing to lie or anything like that. I think it's the fact that he's missed, or seems to have missed, could be substantial parts of the evidence in this case.
Well, it might be best to just ask him about it. He's going to say he's going to say one or the other. Yes, Judge, I was sleeping. Don't really remember anything. Or no, Judge, I'm fine. I'm good to go. And he's under oath.
I guess what I would say is that the only answer that I would really be comfortable with in keeping him as a juror, if he says something like, I close my eyes to listen to the evidence because it lets me focus better, something like that. So he's not actually asleep, that's just how he consumes audio. I do that sometimes, so it's...
Because you remove one of your senses so the others are more keen.
I don't think I can do that much, but... Yeah.
If we removed every juror that we had some alertness issues from a panel, we wouldn't finish many trials. If the standard is absolute perfect alertness, then we'd be hard pressed to ever get 6 people or certainly 12 people back into it. Clear, and that's what's most important, that the record's very clear about this and this issue, and he gets to deliberate.
The most important would be that she gets a fair trial.
And the state gets a fair trial. This could cut against the state. There is no guarantee.
Because it was your evidence.
It was my evidence. I'm not over here. I'm trying to be fair to the process.
Y'all let me meditate. I'm willing to accept what he says as true. And I want to say that that's what he'll do. He will tell me yay or he will be honest and upfront, and he will tell me yay or nay. We need to talk about it in the morning. We need to talk about what we want to do in the morning. I don't want to, before the state puts on its case, challenge this juror on whether or not they're sleeping. We'll just have to, after all of the evidence is presented, the alternate. And it would need to be the alternate on the very far right, because that's the one that we know we've not had a sleeping issue with.
I think the one that, okay, we said the same thing, that the other
That
guy
juror was
was,
sleeping too?
no, I think what he's saying is the second person was number 5, not an
Yeah.
alternate, correct?
But I think that what we observed from the tan person, the tan jacket, makes it not as clean. Because if we didn't observe anything, it would be easy just to go, boom, knock it over to that guy. But because we observed something with the tan jacket gentleman, there's something to even talk about. But for that one little moment, that guy has been he has been in rapt detention in this trial. I have no concerns about his appreciation of the
Okay.
evidence.
But what I'm saying is, if juror number 5 comes in and says that he was asleep, I'm talking about who his replacement would be.
Yes, and his replacement should be tan jacket. That was the first alternate.
Tan jacket, who was also sleeping.
Tan jacket, who we observed there was one moment where he appeared to be fading in attention. That is the next alternate, and that's how we should treat him. He has been paying absolute rapt attention to this case, and I think it would be a
Tan
disservice.
jacket.
Yes.
Okay.
To both parties to remove a juror who is clearly that engaged with this evidence.
I think I know, but I just need to make sure. So I'll tell you in the morning. But we have an option.
We do, but I don't think it's necessary. We should move through the alternates in the order they were selected. They were selected in a particular way.
But one of them might not be fit to serve.
Well, then we should do the same inquiry with tan jacket. I'm saying that we should not jump. We should not make assumptions. Just like I'm saying, we don't make assumptions about 42.
Okay, well then that's what I'll do tomorrow.
We should.
I will talk to juror in seat number 5, and I will talk to alternate number 1, and I will see if they are sleeping during the testimony to the point that they cannot carry out their duties as a juror and fairly and accurately judge the evidence that's been presented.
I think that's the appropriate action.
That's what we'll do. And whatever their answers are, they are sworn to tell the truth, the whole truth, and nothing but the truth. That's what I will take. All right, anything else?
I think we're good. Would we expect probably to go late tomorrow?
Well, what
We'll
I'd
do
like to
closing
do
and then-
when they get it, I mean, I think we can stay until 7, and at 7, if they don't have a verdict, then we can just come back on, tomorrow's Thursday?
Right.
Just come back Friday
Okay.
at 9, and, you know, they don't have anything by Friday at 7, we'll come back on Monday at 9. And we'll stay until 7.
Hopefully we don't go that far.
But I think that's a fair time to leave. I don't think we need to stay until 10 o'clock and push the limits like that. That's what we'll do. Once I get the case, our end time will be 7 o'clock. And they'll need dinner tomorrow. Yeah, most likely dinner tomorrow. Anything else now, State?
Nothing further, Your Honor.
Defense, anything further?
Hey, Your Honor.
Okay, I will see you all tomorrow morning at 9. Okay, everyone have a good day. We are adjourned.